RFA matter for admission. This is a case of appeal.
Just 1 minute, please. Ask him to stay back. The execution filed?
I believe it has been filed and they are moving for stay.
When is the date in execution?
Certain.
Please let us know. So we will depend upon that only, we will list the matter.
Yes.
Just come after lunch.
Yes.
Please let us know. Just leave it.
This is a case of appeal, my lord. A reply statement has also been filed long back. And the last 30th January 25 was listed, but it was not posted. Therefore, on Friday 7.
What is the urgency?
Urgency is I am out of service since 5.5 years.
The challenge is to what?
Challenge is to that
Is
dismissal.
that the tribunal?
No, this is the private educational institution, my lord.
Okay.
So writ petition, a single judge has already allowed it. And the contempt proceedings are also filed.
Take it, ma'am.
Please. Right.
1 minute. Is the other side appearing in this?
Yes, I have given the acknowledgement also.
No, you will inform the date also.
Yes,
of the respondent.
yes. I have shown this one and then got the signature.
Now, we will give date, you inform them.
No,
The
along,
date
along
also.
with the date only he has seen and then signed.
That's a further date.
She's giving the date now.
So it's okay.
Further
It's okay. Accept.
25 to 25.
I am appear for respondent, my lord.
Just
Literally-
take an acknowledgement and give it. Yes.
Respondent, my lord. Itrali 30% deposit ಮಾಡಿದ್ರು.
English.
20% 30% deposit ಮಾಡಿದ್ರು. ಆ ಅಮೌಂಟ್ ರೀಫಂಡ್ ಮಾಡ್ಕೊಳ್ಳಕ್ಕೆ ಐಎ ಫೈಲ್ ಮಾಡಿದ್ದೀವಿ. ಮೆಮೊ ಫಾರ್ ಪೋಸ್ಟಿಂಗ್.
Seeking to withdraw the amount deposited. You are for respondent.
Oh, yes, my lord.
It's an IA.
Oh, yes, filed IA, memo for posting.
Objections clear?
Clear, my
The
lord.
IA.
Clear, my lord.
You can just.
Opposites.
ಅದ್ರ ಮೇಲೆ ಬರೀ ಅಬ್ಜೆಕ್ಷನ್ ಕ್ಲಿಯರ್ ಆಗಿದೆ.
Just inform the appellant's counsel also.
Date
25 to
25 to inform ಮಾಡಿ, you take acknowledgement from the appellant advocate.
Objections clear?
My lordship,
6.
commercial appeal, my lordship, and for the respondent, my lordship. The petitioner deposited the 50% of the amount, my lordship. I file application for release of amount, my lordship. That is it.
You have to inform the other side.
I will
They
inform.
Give you that.
Please, oblige me.
RFA 460
Yes, ma'am.
and RFA
14 to, sir.
Please.
Yes.
My lord, RFA 469 and 370 bidu, my lord. Our petition is aged.
Then
RFA 469/22, RFA 370/22 clubbed. So petition is very aged person. Petitioner is very aged person. That's why it is very
you
urgent.
file an early hearing. You file an early hearing application.
Okay.
Serve the other side. Then we will list it. Yes.
I'm the appellant in a commercial appeal, Manoj. I've supported decree of about 15 crores. The decree has been stayed. I have been deposited back. I have given bank guarantees to Honorable Court, my lords. It's not come up for hearing after stay, my lords. I'm
The year.
on a 2021 matter, my lords. I'm,
File an early hearing,
please, my lords, I'll file an
not
application.
on a memo. File
Please,
an early hearing, serve the other side.
My
we
lord,
will-
my learned friend for respondent number 1 is present.
No, you are mentioning or he is
My
mentioning?
lord,
File an early hearing.
please, my lords.
Better would be that, not on a memo.
Please, my lords, I'm ready.
And let him appear also on the when the early hearing is listed.
Please, my lords, I'm ready.
Lord, the respondent has filed a suit for specific performance of the contract. They are alienating the suit schedule property, my lord. There is an urgency. It's a fresh matter, my lord.
Is it a RFA?
Please, ma'am. RFA.
Now, what is the urgency?
They are alienating the suit schedule property.
When was the decree passed?
The decree has been passed in the year 2023.
Then why now an appeal?
Lord, to 2024, my lord, immediately we have prepared an appeal. There is no continuation.
Objections?
No, there are no objections. We are clear.
That you didn't get it listed?
No, it has not been.
Just take it.
Twenty-five-two.
Yes, just one.
Twenty-four.
Yes.
My lords, I'm appearing for the petition on this matter.
Any caveat? Objections removed,
No, he has to serve and give.
objections removed,
Objections are clear.
clear?
Clear.
I'm appearing for the petitioner, my lords. I had applied for the post of a senior technical assistant and the same was rejected. I had filed an OA and the same came to be rejected. I filed this writ petition before this court. Now, my lords, the issue is that a list has been released, my lords, for shortlisting and my name is not there. So if this matter is not heard, then the writ petition would become infructuous, my lord.
Was the list issued?
The list was issued on December of 2024, my lords.
Your name is not there. Who is the other side?
There is no other side, my lords. Coming up for the first time, the matter is,
The OA dismissed.
it was dismissed in 2017. I had filed the writ petition in 2021, but the office objections were not cleared. I had recently come on NOC.
This we will not.
I had come on NOC, my lords, only recently.
Ma'am, what NOC? The litigant is the same?
My lords,
The litigant is the same?
the litigant is the
Then
same.
what is he doing?
Uh,
This way.
My lords,
List is coming. Where is the list? How do you know the list is coming?
the writ petition would become infructuous, my lords.
So that's a different submission. We are asking you, how do you know the list is coming?
He had, he is just,
We'll give you in March first week. Okay? There should be some deterrent for the delay. Just take it. You should move fast. Well, the litigant also. Just give it whenever, just give it in February, last week.
27-2.
wait,
Take this and all objections cleared,
please, my lord,
everything.
please.
Yes,
RFA 2760/24,
fun. Let's go.
not listed before.
Yes, what is this?
For fetching performance.
Yes, you were the defendant there.
Yes, madam.
What happened now? Be against you.
Yes, madam.
RFA file.
RFA can, my lord, respondent to trying to proceed the final decree proceeding next week. Very near.
You have removed the objections in the RFA.
Clear.
All,
Yes, madam.
everything. Any execution filed?
Yes, madam.
When? What is the date?
12/12/2012. 18/12, my lord.
18?
12, madam.
What is the next date in execution?
Next day, 28.
Have you
28.
received notice?
Yes, madam.
When?
See,
Let's take it.
come up.
Let us see. Take it.
Yeah. 22 on, sir, my lord.
That one fresh RFA matter for admission. Put for partition filed in the year 2007. On the earlier occasion, on the application filed by the defendant for state complaint that has been allowed against which an appeal was preferred before this honorable court. The court has allowed the appeal and remanded the matter, directing the trial court to dispose of the matter on merits. But once again, a similar application was filed by another defendant seeking for rejection of the plaint. That application came to be rejected, against which a CRP was filed before this honorable court. That has been allowed. Now, on the basis of the order passed by this honorable court on CRP, the trial court has once again passed the order rejecting the plaints on technical ground. But the agreement has been executed by the defendant.
It's for suit for
Partition.
Who had filed those petitions? Is there any purchaser there?
No, madam, the one of the sharer of the properties filed the application. Second round of
We'll have it in March first week.
please, madam. And now the steps are taken to alienate the property by farming sites in the
When was the
agricultural
decree
property.
passed? When was the decree passed?
And it was passed on 27/9/24, and I filed the appeal on November 2024.
Then why it's so much late?
That there was some office objection which I was required to attend to the objections.
And was there any stay below?
No, madam,
There was no stay in
There
your
are-
favor.
the suit was filed in the year 2007.
That's right.
There was no temporary injunction.
There was no temporary.
Now, my lord, the taking advantage of the dismissal of the suit, the properties have been developed.
Did not press for a stay before the court below.
At that time, my lord, there was no threat of the property being developed. Please.
Notes
Yes.
one RFA, my lords, wherein respondent 2 to 4 are the plaintiffs' lords. They had filed for a suit for declaration and injunction, which was decreed on 28/7/2018, my lord. The contesting respondent, my lords, has filed the RFA after 5 years on 11/2/2022, my lords. In the respect of IA also, we have filed our objections, my lords, that delay is more than 5 years. My lords, it was
You
last,
What do you want?
no, so it was last listed on 5A. I want the matter to be listed on IA for.
You have filed your wakalat?
Please, even
Filed your-
objections are,
filed the early hearing.
objections are filed, no, delay is not condoned.
File the early hearing. You can file early hearing,
Please, no,
file early hearing. This is a pending matter, na?
pending matter,
Pending is appropriate is early hearing. Okay?
because when it was listed last time, it's 5/8/24, it was directed to be listed after we.
That's right, Mr. Pramod. Was any date given?
No, my lords.
The point. No date given means file an early hearing, okay?
I'm for the appellant in RFA number 270 of 2022, my lord. In this case, I already filed the LR's application of the respondent number 5. The respondent LR's of the respondent number 5 try to transfer the mutation and try to alienate the property, my lord. I have urgency to bring
Is
the
it a
LR's
fresh appeal or
to
is
the
it a pending matter?
pending matter, my lord.
File an early hearing. File an early hearing. Okay?
It's urgent, my lord, because
That's what we are saying. You file an early hearing and then mention it. We'll get that early hearing listed. Okay?
Yes.
Yes.
Melos, MFA 145/2024, Melos. It's an arbitration matter, Melos. I am for the respondent. Melos, the arbitral proceedings were initiated in 1996, Melos, and the award was passed in my favor, Melos, in 2007. Arbitration case was filed before the Sessions Court, Melos, for passing of the decree, and the decree, Melos, was passed in 2023, Melos. In my, please, Melos.
Object under
1940
Old
Act,
1940 Act.
1940 Act, Melos. Please. After that, Melos, the stay has been granted, Melos, and it has been admitted. Melos, I am pressing for asking for the file.
An early hearing.
Please, Melos, I will,
An early
file,
hearing.
please.
Okay, any other mentioning?
My lords,
That's
this is a request with respect to serial number 29.
We'll come, there. We'll just mention. Yes, any other
Serial number
mentioning?
50, adjournment.
Just.
51, my lord.
Pages.
Sir, page wise adjournments. Page number 7, 25 and 26. Page 7, page number 8, 27 to 31.
Serial number 29, my lords.
27 to 31. Which number, ma'am?
29. Appearing for the respondents, my lords, I'm requesting a 1 week's adjournment.
Side,
I've informed them.
sure.
They've not appeared. I've informed them.
Them?
Yes, Your Honor.
You will inform or you will?
I have informed.
You have informed?
Yes, yes, my lords, I've informed. Any new date given shall also be conveyed.
Stating that from the council appearing for the respondent to be notified.
My lords,
3rd of April.
serial number 26, my lords. I have informed the other side, my lords. I'm appealing for the appellant.
26, same order.
Please, my lords.
26 also same order.
3rd April. Page number 9, 32 to 36. Page number 10, 37 to 41. Page number 11, 42 to 48.
Serial number 43, my lord, I appear for the appellant. I have informed the other side also, my lord, a week's accommodation, my lord.
At the request of counsel for the appellant by stating that he has informed the counsel for the respondents. Adjourn to
3rd April.
Serial number 45, my lords. We have informed the other side as well. Kindly have it
And
on
for the
1st
respondent,
of March, my lord.
for the respondent, my lord. For the appellant for an adjournment stating that she has informed.
Date may fixed, my lord.
To which the counsel for the respondent has no objection, adjourn to.
3rd of April.
Next.
3rd March may kindly be, my lord.
Trolley, please, next.
Serial number 45, my lord.
That's right, we have given you.
Yours is 45.
3rd
now.
April.
My lord, serial number 44, my lord. My lord, a short accommodation, the respondent has been informed.
Pardon?
Informed the opposite side.
The request of counsel for the appellant, same order, by stating that. Next.
3rd April. 3rd April. page number 12, 49 to 52.
51, my lord. Serial number 51. I'm for the respondent 3 and 4.
51.
51.
Yes.
I'm for the respondent 3 and 4. I pray some time. My friend is also here.
I'm for the appellant, my lord. Date may be given.
You have no objection?
No objection.
At the request of counsel for the respondent number 3 and 4. For an adjournment which is not opposed, adjourn to.
8th of April. Serial number 1. Mahesh Chowdhury.
Appearing for the appellant, your lordship, I apologize for the office objections not being complied. A week's time may be granted. All the office objections will be complied, your lordship.
The office objections.
9th of April. Serial number
Grateful.
2. Shri
Appellant,
Surya Narayan Rao.
appellant, my lord.
Notice be issued.
Respondents number 2 and 3 were placed, were absent in the arbitration proceedings and also in the subsequent AS.
One.
Only one is the contesting. I think we can permit only sending of a
You
note,
will dispense with at your risk.
please. 2 and 3 may be dispensed with.
Just say that notice to respondent number 1 be issued, returnable on. Then at the risk of the appellant, notice to respondent number 2 and 3. Notices to respondent number 2 and 3 are dispensed with.
16-4. Serial number 3. Shri Gautam.
The fresh notice
My lord,
be issued for for this
1 week time for process, madam.
notice.
16-4. Serial number 4. Serial number 4.
But I appear for the respondent in this
For
case.
appellant,
Notes matter was remanded back to trial court on 29th October 2024, my lords. It's in evidence stage now
Matter has been demanded back by whom? By the Supreme Court.
by the High
By
Court. my
this
lords.
honorable.
By this honorable.
With the consent of the party, appeal was allowed. Both the parties have filed additional documents. On that basis, like, see, we requested this honorable court to, like, remand the back for, remand the case back for consideration of the documents, like, filed before the honorable court. Therefore, trial court has been insisting, saying that, like, let the documents filed before the High Court be, sent.
Those documents from here to there. You have sent. But now you have to say. Correct. This is, but was required to go there.
Who had filed the documents here?
Both appellant as well as respondents.
So you can't file fresh document, these documents are fresh.
My lord, sir, as far as respondent is concerned, I filed, like, my office copies with the original acknowledgement. These were invoices with the original acknowledgement of the appellant's
So you have filed it here,
Please.
but why did you file original acknowledgement?
We have filed it, like, see, in the appeal for, like, consideration of additional documents.
Here
With-
before us.
Please,
Right. So now we have remanded the matter back.
please, my lords.
Now what does the trial court want?
The trial court wants these documents to be, like, see, sent to them.
What will remain here?
Lords, I will substitute that with Xerox copies.
So we want to know what is the difficulty for you to file the fresh documents there?
As far as the respondent is concerned, I'm submitting that original acknowledged invoices were, like, produced before.
Show us.
Please. This was the application filed on 15/4/2023. The lordship would get the documents with the acknowledgement, original acknowledgement 13/4/2018, signed by the
Xerox.
Just show it. It must be here.
Okay, first set.
See, when do you require these documents?
These are the documents to be considered by the trial court as an additional documents. The matter is posted to 7th.
Any issue on the immunity of these documents? Anyone is contesting?
That was the main contention by the appellant,
Then do.
saying that I did not produce this document, therefore no license.
Will it be an oral submission or there would be a cross-examination also?
There will be a cross-examination.
So then at that time, you can ask for the, we don't want to segregate these documents from the file. You can ask, we'll send the whole file for the purpose of examination. We can do that.
Great.
Okay.
Please.
You don't want to separate it. If it is there, unless and until there is a separate application file for the return of these original, we can decide that. You're getting the point.
No, I get it. No, like, if your lordship insists that, procedure be followed, I'll file necessary application for return of the document and then null see. Because 6 months time is there. Trial court is very insistent that null see. I will consider only those documents produced before the High Court. That is the reason.
When is the date?
7th.
What are the proceedings for on 7th?
For marking of these documents.
For marking of these documents. We'll do one thing, we'll send the file. In any case, one day will come and you will seek the return of these documents, whosoever has filed it.
Please.
Either the other alternative is, you have filed these documents,
Please, please.
we'll take your oral submissions for the return of these documents.
Please.
You will file the photocopies of these documents duly certified, saying that the
Please.
2 copies of these documents. And
Please.
we'll allow the registry to return you back. You file it there.
Please.
That's another alternate.
Please. There are 2 sets. There are 2 sets filed, like because it's division based.
You just check up, you don't.
ಅದರಲ್ಲೂ ಹಾಕಕ್ಕೆ ಹೇಳ್ಬಿಡಿ. ಇದರಲ್ಲೂ ಒರಿಜಿನಲ್ ಅದರಲ್ಲಿ ಜೆರಾಕ್ಸ್ ಹಾಕಕ್ಕೆ ಹೇಳಿ. ಹಾಕ್ಬಿಟ್ಟು ರಿಟರ್ನ್ ಬೇಕಾದ್ರೆ ತಗೊಳ್ಳಿ.
Sir, one more set, photostat copy.
ಇಲ್ಲಿ ಕೊಟ್ಟು.
ಇಲ್ಲ sir.
ಅಲ್ರಿ ಅದರಲ್ಲಿ ಹಾಕ್ಬಿಡಿ. ಫಸ್ಟ್ ಸೆಟ್ ಅಲ್ಲೂ ಫೋಟೋ ಕಾಪಿ ಹಾಕಿ ರಿಟರ್ನ್ ತಗೊಳ್ಳಿ.
ಆಯ್ತು. An order may be passed, like I'll submit it in the office.
Just say this appeal has been listed today in view of the communication letter, in view of letter dated 28/1/2025. Received from the senior Registrar, Commercial Court Unit, City Civil Court, Bengaluru.
Furnish these documents.
Stating that we should send it.
Yes, yes.
Huh?
Yes, it requires. It says that those documents are required for necessary.
Stating that
No problem.
we'll send the entire file. Stating that the documents as filed, full stop. Suffice to state that the appeal was disposed of by this court on 29th October 2024. Whereby we have in paragraphs 6. In paragraph 3 onwards, as under Full stop. The trial, just say that the trial court in its communication dated 28/1/25 has sought the documents as filed by the parties herein. When did you file it on
15/4/2023.
2023 bracket by respondent, and when did you file it? Appellant.
exact date.
No, appellant, you 2/1/2024. We don't know your documents are original or not.
No, that was it, Xerox. They filed only copies of it.
Copies.
Right, so your copies need to be sent there.
No need.
No, but the trial court wants to see only these documents which are filed.
Exactly.
Full stop. It appears the intent of the trial court is to only consider those documents which have been filed by the parties in this court, in this appeal, of which a reference has been made above. If that be so, just now both of you check up, these are the documents. We don't want any confusion later. You also check, and you also check his, those are the side, and please flag it. You just give them the flag. The date is 15/4. Check up the date also.
Please. Copy there. One second. Oh, 2/1/2000.
Yes, my lord.
You have 2/1,
Yes, my lord.
2000, and yours is 15.
15/4.
Full stop. We said, when the counsel for the party states that appropriate shall be, we are saying that the whole file be sent according to you.
If IS can be sent, which is separately,
Don't
please.
want to separate,
I-
we don't want to separate it. We want
Please.
the file as it is.
Please.
Full stop. Though the trial court has asked for the documents to be sent to it, we are of the view that the complete file of this appeal, which includes the said documents, shall be sent to the court concerned in a seal cover to a responsible officer. After the proceedings are over, when is the date of hearing?
7/2.
Seven-
Day after tomorrow.
Day after tomorrow. We have been informed the date of hearing before the trial court is 7/2025. After the proceedings are over, the file shall be retrieved back. Okay,
Please.
to this court. That's all.
Great.
The aforesaid order shall be in response to the communication dated 28/1/2025 of the trial court.
Great.
Thank you.
Bill number
Hearing for respondent.
bill number 5.
For the appellant.
Pardon? Yes.
For the appellant. But I have not received the appeal copy.
You have not received?
Not received the.
I beg your pardon, my lord, I will pass on copies to him. I don't have the surplus copies, I will send it. ಕೊಡ್ತೀನಿ ನಾನೇ. inadvertently, my lord, there was one order on 4/7/2024, wherein, my lord, I was supposed to carry out the amendment to the prayer, my lord. I will carry it out, my lord, within
Say
a,
that you will comply with the office objections.
please, my
Have
lord.
you given a copy of the appeal?
I will give, it's a surplus copy, I don't have it, my lord, I will give it.
Let a copy of the appeal paper book be given to the counsel for the respondents. All the
No respondent, my lord. On the last date of occasion, respondent number 2 has been exempted because she is now diverse to the defined number 1 and it has been recorded in the track.
For one only,
Yes,
only,
my lord,
the respondent number 1.
one.
Who is dispensed with?
Yes,
My lord, at his instance only, he has undertaken that for and on behalf of the second respondent also, he will obey the decree.
Further, the counsel for the appellant shall remove the office objections within 2 weeks, list on.
Three,
Next.
serial number 6, government advocate. 6,
I appear for the respondent number 2, my lord.
Did I state, my lord? Lord, there are two objections, my lord. First objections, my lord, we have served the copy to the respondent number 1, my lord. Have the endorsement with me. And so far as written submission is concerned, my lord, we will file it.
I respond number 2, my lords, Karnataka State,
R1.
R1.
Ma'am, have you served the R1?
Yes, my lord, I have the acknowledgement.
I whom?
My lord, that is measures Invector, my lord, Info Solutions.
No, but have you served the counsel or
My lord, we have served them personally, my lord.
the respondent himself?
Yes, my lord. And we've got the endorsement also.
Just show us the acknowledgement because
Please,
it is
ma'am.
based in Hyderabad.
Please, ma'am.
Just check out that.
But it steps Hyderabad.
No, but you say advocate, man.
You are served advocate personally?
Please, my lord.
Huh?
Yes, my lord.
That's all. But he is represent.
Has he filed wakalat for him, for the respondent number 1?
My lord, we appeal, state appeal, my lord. This is,
Correct.
this appeal is preferred by state, my lord.
Been noticed to R1.
Please, my lord. It may be dispensed with, since we have already served them. My lord, we have served them personally, my lord. That is,
Means whom? Counsel or the party?
I think it is the managing director, my lord.
No, it says Sanjay Krishna, advocate,
It is
care of.
Care of, my lord.
The office is
My
at
lord,
Hyderabad.
it is served on 1 BK Dwarka.
I'm just.
We will take steps, my lord. Anyway, we will take steps.
And where did you serve? Did you serve here in Bangalore and Hyderabad?
Hyderabad, my lord.
Oh.
Nothing is written here. But they have acknowledged.
Yeah, right. We can take, we are ready to take the acknowledgement. Very well, we'll go by this acknowledgement, whatever
Please.
it's worth. But later it should not be found that the notice has not been issued to respondent number 1.
My lord, we will take one more time steps.
Would be that.
Please, my lord.
Though acknowledgement though an acknowledgement has been filed by the counsel for the appellant depicting the service of the appeal on the respondent number 1, from appropriate shall be that a notice is issued to respondent number 1 returnable on.
My lords, one more submission, my lords. Even I have filed an appeal challenging the very same judgment, my lords. Respond number 2, my lords, Karnataka State.
Do it.
Bearing appeal, commercial appeal number 140 of 2023, my lords.
Is it listed?
No, my lords, it has to be tagged along with this matter, my lords.
When is the date there?
My lords, date is not given, my lords.
You will file an application or a memo.
Please, my lords.
Okay? We'll give you a date, possibly get it listed on that day.
Please, my lords.
Written submissions, we will file it.
Then the submissions will also be filed by the parties before the next date of hearing. Next.
Obliged.
7th of April, serial number 7, Srimati Lata Shetty.
Here for the appellant, there's a await notice with respect.
Including serial number 7, I take notice for respondent number 1.
It says this. Who appears for two?
Await
In
notice.
person. Shri Umapati, party in person.
My lord, there is a caveat for respondent number 2, in person, party in person has filed a caveat.
Correct.
Has he been served, man?
Awaiting.
No, sir, awaiting, sir.
Okay, so the notice to R1 and R2 is still awaited. From where so and so appears and states that he shall appear and accept notice for respondent. The respondent number 2, the service still being awaited for respondent number 2, fresh notice be issued for service on respondent number 2, returnable on. Okay, we'll do one thing, just cut the last sentence. Then they let the service report with regard to respondent number 2 be placed before the court on the next date of hearing.
Please, ma'am.
I pray for a short date, my lord. I pray for a short date to be granted. my
We are
lord.
giving you a date. You have to serve the respondent number 2.
He is already on caveat and not appeared.
So no, he's not appearing.
Please.
10th of March,
Next.
Sure, ma'am.
serial number 8, Shri Manjuna.
Finish for the appellant, my lord.
And for the,
For the regular, respondent number 3.
I number 1 of 2024 filed by me for impleading the proposed respondent number 5 and 6. And they also come up on record, my lord, they also filed the I number 1 of 2025. Accordingly, the full cost date is not required, my lord. It may be, and office objection may overruled.
Does it say 1 of 24? Let's see your 1 of 24.
For impleading it. At 1 to 2. Filed on 3/10/2020.
Who has filed this application?
Appellant, my lord.
Yes,
Subsequent purchase of
file.
full cost title, office objection is raised on this,
Hmm.
furnishing full cost title. They, the results come on record, my lord, by filing the I number 1 of 2025.
Just over this one. Now, the same confusion. You also filed an application,
same,
same application.
independently,
You also want impleadment of those two persons?
implead us, same respondent, but
You are the persons like Chandrakala Umesh and
yes,
HR Umesh.
yes, we filed,
We can allow that.
similar application. Anyone,
You withdraw that application.
yes, ma'am.
We'll allow these applications.
But wakalat is concerned, I filed wakalat on behalf of the proposal from 5 and 6 along with the application.
Make any difference, we take that wakalat.
Okay.
Just say this, go to an objection. The objection of the, just say this is 1 of 24, right?
Yes,
The
sir.
objection of the registry. That full cost title has not been produced in this IA. Some of the same is overruled. This is Sidhu and others.
Second, sir.
This is an application seeking
Withdraw ಮಾಡ್ತಾ ಇದೀವಿ.
under order 1 rule 10(2) of the CPC 1908 for impleading Srimati Chandrakala Umesh and Sri HR Umesh
Yes,
as respondent number 5 and 6 respectively. Who appears for 1 to 4 otherwise?
I am representing the respondent number 3 only. 3 only.
What is your good name?
R. Chandrakumar.
Mr. Chandrakumar, whose advocate states that he has also, who appears for respondent number 3.
3, presently 5 and 6.
3 state that he has also filed an application being IA 1 of 25. for impleading the aforesaid persons as respondents 5 and 7. Mr.
5 and 6.
6, in view of the fact that we are allowing, in view of the fact that a similar application has been filed, which we allow by impleading Srimati Chandrakala Umesh and HR Umesh as respondent 5 and 6, IA 1 of 25 has become infructuous. The wakalat filed by Mr.
R. Chandrakumar.
Mr. Chandrakumar.
R.
along with the IA 1 of 25 shall be taken on record. Just say that for the respondents 5 and 6 shall be taken on record. Have you filed wakalat for 3?
3 filed. Caveat.
So the IA 1 of 24 is disposed of. Let amended memo of parties be filed within 2 weeks. Necessary corrections be.
Matter has been settled already. We will report day after tomorrow.
Settlement,
Who appears for 1, 2, 3, 4?
The respondent number 5 and 6 steps to the source of the respondent 1 to 1, 2.
Notice may be issued by.
Notice are,
Notice
notice not what is.
Notice
the.
For 3,
R3 caveator. Respondent number 3 caveator.
1, 2, and 4.
But what about 1, 2, 4?
Were they expected in trial court or?
Were they ex parte before the trial court?
They contested.
Then we will issue notice, not like this.
60 days.
Let notice be issued to, we find that 1, 2, and 4.
Yes.
Notice has not been issued to 1, 2, and 4. Let notice be issued to 1, 2, and 4. Returnable on, just give a date.
1, 2, and 4 already sold the property to the respondent.
We don't
know.
know. We will serve them, let them come and say.
Date.
19 Malad. 19th February.
19th of,
February.
will you be able to serve them?
Because already sold the property to the respondent.
I will request them to entrust the what?
We'll just send it, just give it in March. First week of March, service, otherwise the service is not affected.
10th of March.
Please.
Next.
Bill number 9.
Here for the.
You are the advocate for the respondent.
I have served the copies on the other side physically, made an endorsement on my applications 3, 4, 5, filed on 25/10/2024. And office has noted that copies are not being served on them. Apart from that, I have also sent the copies on a WhatsApp 24/10, 24/1. I have the copies of the WhatsApp message received by them.
I'm not disputing service. Service has been made.
Pardon?
I'm not disputing service of the IAS. And learned friend is at pains to establish that he has served. I'm saying I have received, no problem. Objection file now.
No, what about the office objections?
I have served the copies, my lord. They admit
The copies on,
defendant only, respondent only one.
IA 3 and 4.
IA 3, 4, 5.
you
I
are
have
also list.
There's only one respondent, I'm
What
okay.
has to be done?
But in fact, my learned friend is now seeking some further interim relief. There is already an interim order operating against me. Now he is seeking for some other reliefs.
Before
My
that,
submission is this, that paper book has been filed. We may as well just take it up for final hearing and be done with the appeal itself.
before that, my lord, I have filed a memo complaining the order of this honorable court for condoning delay in filing an appeal, 1,000 rupees. Delay was there. It was condoned with a condition to pay 1,000 rupees. That I have filed with a memo along with this. That may be taken on record, my lord. And there was also a direction.
You filed the memo?
Memo along with IAS.
Along with the is dated from
dated 28/10/24.
A memo dated 28/10/2024 has been filed by the counsel for the appellant, stating that an amount of ₹1,000 imposed as cost has been deposited with the Advocate Welfare Fund on 25/10/2024.
One more memo.
In this regard, a receipt issued by the State Bar Council has been annexed. Now, what is the other memo?
Other memo is I was directed to pay the decretal amount of 1,89,600 rupees, 60. I have paid it. I have given the particulars of the payment.
You have
Complied the,
you have deposited before the city civil court.
yes,
Full stop. He also draws our attention to
Application.
a memo dated 28/10/2024, showing the deposit of an amount of 189,660 before the Registrar City Civil Court, Bangalore. The Registrar City Civil Court, Bangalore shall give his report. Is it in execution petition?
yes,
Yes,
my
my
lord.
lord.
In execute, just say that 189,660 in execution petition 2554 of 2023. The Registrar City Civil Court shall give his report on the next date of hearing.
My lord, now,
Has to be done.
now I have complied the decretal amount. Execution is pending. Now the suit for declaration and permanent injunction. During the course of judgment, the court finds it permanent injunction is not amenable. It is only a physical position is ordered. I have taken, they have taken position in the execution proceedings in the month of 26/7/24. So I am out of possession. I have completed the decree. Now the appeal is a continuation of a suit. So I should be put back in possession is a one aspect of the application. Another aspect is a stay should be granted under 41 Rule 5 since appeal is continuation of the suit. The third point is IA, the GPA with a sale power followed by a sale agreement on a same day had to be impounded. Inadmissible document came to be admitted. As per the Supreme Court ruling, even if it is admitted, the court has to pass a judicial order with regard to admissibility of the document. Latest judgment of 2024, Justice, I don't remember. Now I'll place your lordship that judgment, which Deepankar, that justice, and SN Bhattina.
Pankaj.
Okay, we'll hear you. We'll set out the RFA for hearing.
That's right, man.
Please.
We'll set out the RFA for hearing. Full stop. Just say this. Has it been admitted?
Yes, ma'am.
Yes, yes, admitted.
So let the paper books be filed within.
Filed already, man. That's all.
High Court record is coming.
High Court record
Yes, to be-
may not
If required,
Paper book has been filed, my lord, may not be required.
it's the appeal for hearing.
Meanwhile,
In
17/4.
the interim order, he will not alienate the property.
yes, my lord, that
I
has to
got
be
it.
extended.
That's-
And I should be put back into the position.
The way you are conveying, that's your perception, but surely, but the fact remains there is an execution file, he got the position thereof.
Yes, my lord.
Maybe appeal is a continuance of the suit, in that sense, you are right. But the issue need to be decided first
Yes,
to grant you what you are seeking.
yes. My lord. A date may be fixed, my lord.
Yeah, we are fixing the date.
For 17/4.
My lord. Can it be done sometime in March? I am suffering an interim order, my lord, after all this litigation.
It's very difficult, Mr. Joshi.
17/4.
They're telling you difficult.
Very good. 7.
I've also produced the water bill, electricity bill. The premises is vacant, nil reading is there. Either he is using or not, I am using it. I have produced the reading of electricity and water meter, which shows the nil reading.
What follows?
What follows, liability of payment of taxes also rest on them. I am not able to enjoy. Neither I could enjoy or he could enjoy. Therefore, I sought for redelivery of position under section 151.
We look into it. Thank you.
Grateful, my lord.
Supreme Order, if I need to continue. till the
Please.
next item.
Great.
Serial number 10.
Please, minutes. For the appellant,
APA for response 1 to 81. But there is a compliance which is to be done by the students. May I just share a memo, my lords, where I have reported compliance. There are a total of 39 lots.
Pele, we want to understand what is this issue, what is this
Let's-
payment of 75,000?
yes,
What
madam.
had happened,
May
lord,
I-
where, may I just,
May I submit if my learned friend,
very well, very well.
because I am for the college, my lord. They joined the college sometime in 2016, my lord, 16, 17, 17, 18. Fees were paid. Then so far as 18 onwards, the fees were not paid. The students got the were imparted education, medical education, 5th semester in 2018 and the 6th semester in 2019, my lord. Thereafter, but in the first, in the January 2019, they approached this honorable court and they said that there are some lacunae in the functioning of the college and therefore some report which has been given by MCI may be looked into and we are not satisfied with the teaching in the college. So we will deposit this amount, whatever belonging to any of those classes, categories like management quota or the direct quota or so on, before this honorable court, my lord. They deposited the amount before this honorable court, my lord. Then the litigation so far as their
Commensurating what?
the fee for the year 2018-19, my lord, 5th and 6th semester, 5th and 6th semester. So, and then after 6th semester, they were directed to go to the other colleges, my lord, that because of the litigation and the orders passed. So they have joined other colleges. The students, they say that so far as 5th and 6th semester is concerned, that they are entitled for the repayment, refund of the fees. Whereas the college, we are saying that we have given you, imparted the education for 5th and 6th semester, and you have also attended the classes for that. You have passed the examination of the second year, that is in December 2018. And so far as the sixth term is concerned of the third year, that also because the internal examination you have passed, therefore you are not entitled for that fee, my lord. This dispute, and when they had filed an application and we had filed the application before the learned single judge, and single judge has passed an order that they are entitled to it, this amount, my lord.
They are entitled.
Yeah, they were entitled for the refund, my lord. So we challenged it before this honorable court. And when this matter was being listed, my lord, this honorable court has passed the order that on 15/4/2024, my lord, when the matter came up for, say, admission, my lord, notice to the, kindly peruse the order, my lord. On 15/4, my lord. Notice to the respondents returnable by 25/6/2024. Learned Advocate Shri Ajit Anand Shetty accepts notice on behalf of respondent number 1 to 81. Learned Additional Government Advocate Shri Srimati Nilofer Akbar accepts notice on behalf of the respondents 84 and 85. The appellant is also permitted to serve learned advocate who appeared for the respondent 82, 83, 86 in the proceedings. After hearing the advocates for both the sides, it is provided, it should be directed that there shall be no withdrawal of the amount by the petitioner students. So, but however, in spite of this order and after the learned advocate had taken notice for them, they have withdrawn the amounts, my lord. They have withdrawn the amounts, and on 22/8/2024, my lord, the learned advocate for them has filed this memo, my lord. That memo is called out in the order, my lord, dated 5/11/2024, my lord. 5/11/2024.
511.
24, my lord. Lordship could get it? Yes, my lord. The memo reads as under, the contesting respondents in this appeal would respectfully submit that in terms of the accompanying table, a majority of them have received sums that they had respectively deposited in the registry of this honorable court, with interest accrued thereon by means of electronic transfer. This transfer has occurred notwithstanding the interim order that is in place in the present appeal, and such transfers have happened by sheer inadvertence. The contesting respondents would most respectfully submit that none of them have any direct or indirect participation of such transfers, and as such, there was and there is no intention on part of them to violate the interim order granted by this honorable court. The contesting respondents are also willing to redeposit such sums if so ordered directed by this honorable court. Then this honorable court passed the order, wherefore the contesting respondents would most respectfully pray that this honorable court be pleased to accept report of such development in the interest of justice and equity. In view of the above.
Transferred back to their respective accounts.
Yes.
No, they were, yes, my lord. And that is the schedule which my learned friend has given along with his memo which he had filed.
Was that done?
But what had happened, my lords, from the date of the order that was passed by the learned single judge till the point in time, my lords, when the writ appeal was filed, there was a gap, my lords, of a couple of months, by which time, my lords, all the students had filed necessary papers, my lords, seeking, my lords, transfer of funds to their accounts. So those papers, my lords, were already in process in the registry of this honorable. Now, what happened, my lords, when the matter was heard? By the time the matter was heard, my lords, and the interim order was granted, the funds had already been transferred, not to everybody, my lords, only a few of those students. Not all students have received the monies. Only a few of those students had already received the money, my lords, by RTGS. It was by way of an electronic transfer, my lords, and as such, my lords, the term withdrawal, my lords, may not be appropriate in this context. My lords, we had no role to play there. That is how the funds came to be transferred, my lords, and then we have volunteered, my lords, to refund the money back to the registry.
How many have to refund the money?
My lords, out of 39 students, my lords, who are noted, my lords, by the registry, my lords, 8 have already deposited the money now. The rest, my lords, are, my lords, have sought some time. My lords, may I just pass this memo? My lords, I've just named the students who are yet to, my lords, pay.
So delay.
My lords, what had happened was, most of these students, my lords, belong to the lowest economic strata of society, my lords. They had garnered these funds, my lords, by availing loans and credit, my lords, from banks.
We don't know in advance. Let's be very clear, please.
Yes.
An amount which has come.
Yes.
Has gone. For what reason, we don't know.
Yes, my lords.
It has to come. 1 week was given.
No, that will be done. That will be done. I only seek.
It has gone long back.
Yes.
August, this order was passed.
Yes.
Around 13/11.
Yes.
11. And we are 3 months thereafter.
May I seek,
Money has still not come.
my lords, may I seek some indulgence? May I
Yes.
make my submissions? My lords, these students do not belong to the semester system of syllabi. That's there.
That would not be relevant for us.
Absolutely.
Once there is an order that the money should come back.
We'll comply. We'll comply. My lords, in fact, may I
You will
just,
tell us, otherwise we know how to take it to a logical end this.
may
We
I,
will not allow this to happen. Once there is an order,
yes, my lords.
it should come,
My lords, the students, my lords, they bow down. My lords, we have,
right?
my lords,
1 week was given.
absolutely. May I just submit this?
Yes.
May I seek some indulgence? My lords, my lords, I'll undertake on their behalf, my lords, in the next 2 weeks, I'll ensure every penny is paid, my lords, back to the registry of this honorable court.
But we don't know what steps have been taken to refund it back from last day to this date.
Now, thereafter, my lords, after the order was passed, my lords, no refunds have been done.
Right?
Yes,
Only why 8 have done, not the rest.
my lords, my lords, most of these students, my lords, they are residing in the northern part of India. My lords, we are in touch. In fact,
We don't know.
Yes.
Otherwise, we know how to take it. Deal
no,
with this.
my lords, I wouldn't trouble my lords, my lords, to that.
We expect that also.
I wouldn't trouble my
We
lords.
expect within 2 weeks it will come back. We
I'll-
expect it after 2 weeks.
Very well, very well. May I seek one indulgence?
Yes.
One indulgence. My lords, I'm not shying away from my responsibility, my lords. All that I'm bringing to my lords kind notices, these students lost a year, 3rd year. They were shifted to other institutions, my lords, which were recognized. They have paid a full set of fees to those
We
institutions.
want to ask him that also.
Yes, we have paid that.
We want to ask him that also. That we will do it once there is an
Absolutely.
order.
I first, my lord, I have to, my lord, prove my bona
That's
fides.
in our mind.
Absolutely.
That means They have not paid you, they have deposited here.
Yes, my lord.
They have gone to a third institution.
May I just correct there also, my lord, it was not they who deposited the money, my lord, it was we who deposited.
What we are saying, you
Yes.
have deposited.
Yes,
here,
yes,
And that's your case, that you will deposit in the court.
absolutely,
And you may have paid it to the third institution where you were given admission.
true, my lord.
You must have paid the fees, we wanted to know that.
We have not placed the records also.
What we were concerned about, did that institution made a claim for the fees for that period from you, the students?
My lord, because
You have already paid.
we have already paid them.
You will see.
We have already paid. But
But
I'll prove my bona fide.
Come back.
Lord, in the meantime, Lord, may I just place this memo on record? Lord, I've just named the students who are yet to pay.
Yes, and we are taking it, and otherwise we will take it very seriously.
Lord, in fact, Lord, may I just pass this on?
Some of the checks which were deposited may not
Three
have
of them-
bounced.
No, I'll answer that.
How many?
also.
No, at the first instance or after this order of the court?
After this order, my lord, they never deposited, my lord, they never firstly, the amounts were transferred only in after the month of June, my lord, after the order was passed.
Let my senior friend, my lord, make.
After
make such
no, yes,
submissions.
yes, we will,
They have filed an affidavit, my lord, tendering apology. One, my lord, has already filed a DD. Two of them, my lord, are now filing the DD with a, my lord, with an
Who are
apology.
those students?
My lords, the 20, my lords, respondent number 20 has already deposited a
Lord.
DD. Now, my lords, response 7 and 14, my lords, they also have furnished a demand draft. And they, my lords, they have filed an affidavit, my lords, tendering an unconditional apology.
may I also
But
guide
they are
you?
all students.
May-
My lords, and may I'll also bring to my lord's kind notice that, my lords, a coordinate bench of this honorable court has clearly held that these students have lost a year.
No,
Have lost a year.
no,
Not here, we will hear you.
Absolutely.
After this order is complied with.
Absolutely. That I'll do. I'll ensure it is done.
And minded, if this is the impression we are getting, even
But
the
it's-
checks which have been given, they got bounced.
My lords, all
Yes.
three of them have complied.
The-
All three of them, my lords, three checks, my lords, were dishonored. All three of them, my lords, have,
Will-
one, my lords, has already placed.
No, how did they deposit in the court physically, the demand draft?
Yes, my lords, one has already been done. Two, my lords, are with me. My lords, if my lords would permit me, my lords, I'll just pass this on.
Without saying, we don't want that need to be deposited. in
Very
the
well. I'll do that.
register.
I'll do that. So I'll do that.
my lord, also, may I also kindly bring it to your lordship's kind notice, because the amounts, the order has been passed, the amount which was transferred to them, some of them have deposited only the 5,77,000 rupees, which was the fee. So the interest which was, that interest also has to be deposited, if they are not deposited.
My lords, I'll ensure compliance, my lords, but then submissions are being made, my lords, to show me in bad light.
No, I'm not showing,
I'm the
this is
victim.
the information.
I'm the victim here. My lords, anyway, my lords,
Yes.
I'll comply with the orders. My lords, I'm bound by that. I'll comply. I'll ensure compliance.
That's one thing.
Yes.
Is that an unreasonable submission? That whatever has been transferred must come back.
Absolutely.
Yes.
I cannot question that.
Finally, you may get back, possibly.
True, my lords.
You say nothing.
We hope so.
So, but whatever has gone back must come back.
My lords, I'll ensure it is done.
What is this? Some amount is paid, the rest is not paid. That we will not take it.
My lords, I'll ensure, my lords, I hope my lords would understand, my lords, the logistics involved, number of students. My lords, my lords, I'm in my lord's hands. I'll ensure compliance.
But we have not mentioned the time period by which.
My lords, I now make my submissions, my lord, because I've now secured instructions. My lords, I've instructed.
And now what will be the deterrent after if you don't deposit within 2 weeks?
My lords, I would only seek indulgence of my lords, my lords, given the
We are
fact.
giving you indulgence. We are showing indulgence. We are asking you. We are giving you 2 weeks.
My lords, I'll ensure it is compliant. My lords, I'll,
Suppose it's not in your,
absolutely, it's not in my hands, my lord.
counsel, it's not in your hands.
It's not in my hands.
Suppose they default. Then
My lords, I've already told them, my lords, that this would come, my lords, at the cost of losing audience, my lords, by this honorable court. I've already told them this. My lords, though they have, my lord, they have bona fides on their sides.
the difficulty is.
Yes, my lord.
None of these students have signed this memo.
My lords, I have,
We don't know they are privy to this.
my lords, in fact, my lords, there is a WhatsApp group created by parents of these students. And my lords, this memo is shared. And that is how, my lords, only after they have expressed this concurrence, my lords, I've placed this memo on record, my lord.
And what about those students whose money have, now you have to tell us, it is the complete amount
Yes, my lord.
which has been transfer to their account, that need to be deposited.
That also, my lords, will be done. I have already instructed them to do so.
You said so that it will be the complete amount which had been.
My lords, I have not said in this memo, my lords, but lordship may kindly record my undertaking, my lords, that even that will be done.
My lord, kindly see the fourth line, what they say is redeposited the fee amount, they say, not the entire amount. Fee amount, they say, fee amount is plus, they have to redeposit with interest. Yes.
My lords, in that case, with abundant caution, my lords, may I seek 3 weeks' time, my lords, just in case.
We'll give you.
Very well, so grateful.
Just say that you appear for all the respondents?
All, my lords, 1 to 81. The rest, my lords, the Union of India and the MCI are also parties.
I'm appearing for Union of India.
Because there were 3 or 4 petitions, my lord. Therefore, there are total 101 students, my lord.
No, we'll just go by this memo here.
Only 81 students, my lords, have been impleaded to this petition. And only a part of them, my lords, have received these funds, not all.
The benefit to,
Council appearing for respondents number 1 to
81.
81 has filed a memo which reads as under. So this memo is pursuant to the order dated 5/11/2024 passed by this court. Stating that the redeposit is permitted to be made redeposit the amount transferred by the High Court. And the same was directed to be made within 1 week. So we note from the memo that many of the respondents have not redeposited the amount as transferred to their accounts. We have been informed that even the 5 respondents who have transferred the amount, redeposited the amount from checks, in some cases have bounced.
3 months, there are 3 of them.
In 3 cases have bounced. The learner counsel for the respondents states that the 3 students shall redeposit the amount which had been transferred to their accounts in terms of the order dated 5/11/2024 within how much time?
3 weeks.
Within 3 weeks from today. But he also ensures that the other respondents between respondents between 1 to 81 shall also redeposit the amount as transferred to their account.
Very well.
Within 3 weeks from today. So he also states that any shortfall of the shortfall in redeposit by the respondents who have already redeposited the amount shall be made within the period of 3 weeks. The said submissions of the council have been taken on record. The registry shall give its report on the next date of hearing. The registry shall give its report on compliance of the submission made by the learner counsel for the respondents 1 to 18 on the next date of hearing. The memo is taken on record.
So great.
any date you also will give 27th of
We are giving it.
please, my lord.
4th of March.
Next.
Serial number 11.
Your lordships had heard this matter last occasion.
Yes. We heard yesterday.
I beg your pardon, my lord.
When did we hear?
My lord, it was heard on 15/1, my lord. Learned single judge has dismissed your writ petition.
Yes. What is the difficulty? We'll hear it today. Pass over. What do you want? We'll pass over the matter. Next.
Till number 12. Srimati Venkatama, party in person.
Venkatama is not here. In person. Is not here. No for withdrawal.
What is this memo filed on 3/2/25?
Filed by
See, this is an IA file. You have seen the impugned order?
With my order.
With the above case.
The impugned order disposes of
In that number.
IA number 1/23. And if you see page 2 of that order, the last paragraph,
Infractions dismissed as having become infractions.
if impleading applicant has any grievance in respect of the land in question, it's open to her to raise the challenge. She has written this, no? Just say this, our attention has been drawn to the memo for withdrawal filed by Venkatama. Couldn't hear him. The memo reads as in in view of the aforesaid memo, the appeal is dismissed as withdrawn.
Committee, okay.
Yes.
Who is absent because of anything in spite of that. But in any case, this is. This is only for appearance in the court. So.
Till number 13. Dismiss. 13.
Today I received the copy of the appeal and annexures, my lord. I need take instructions because inordinate delay in filing the appeal. I have to file objections.
The same appeal which we have filed.
Yes.
Is that other appeal coming?
Tomorrow, madam.
They have listed tomorrow, then what do you
My
want?
lord,
Tomorrow?
my lord, this is, I have received only yesterday evening.
Yes,
I want to file objection because inordinate delay of more than 3 years.
that's right. We will have it tomorrow. We'll see that tomorrow your appeal is listed.
My lord.
There is a cross.
Tomorrow,
appeal.
ma'am.
Who has filed that appeal?
That, that appeal I have filed, my
We'll
lord.
have it tomorrow. We'll see it tomorrow. This tomorrow. We notify them. We have filed it, na? Tomorrow's appeal.
Tomorrow, appeal, or appeal,
And this arises from the same impugned order.
same improvement, please.
Tomorrow.
6
Much.
Till number 14. Shri Mahesh Upin. 14.
This honorable court on 12/12/2022, but pleased to grant an interim order of stay. Subject.
Vivekananda.
Just call the other counsel. Yes.
But this honorable court was pleased to grant an interim order of stay on 12/12/2022, subject to deposit of 3 lakhs within 4 weeks. But due to, I am an agriculturist, my lord, due to crop failure, my lord, and sudden downfall of the market rate of the ginger, my lord, I was not able to deposit that amount, my lord. Now I have deposited that amount, my lord.
You are deposited now.
Yes, my lord. The DD is also put up, Lord Allah.
When were you asked to deposit?
Within 4 weeks from within 4 weeks from date of the orders.
Which order?
12/12/2022.
So where are we today?
Lord, I am an agriculturist, Lord. There was a crop failure, Lord, and I was suffering from cancer, Lord. That's the reason.
Without filing the application.
If this is not, then you should have filed an application.
But I have filed an application for extension of.
When?
That application is put up.
We want, what are the reasons given the application?
But reasons is that, Lord, I have stated in Para 4, Lord.
See, otherwise for 3 years, you did not deposit.
The exception case, Lord, where ESL last.
You have not also initiated execution. Has he initiated execution?
I think, Lord, he has not.
So have you deposited this amount?
DD is put up, Lord, here.
Where is it put up?
Office note says.
Seeking permission to deposit the same. Seeking permission to deposit the same.
Yes.
But I have no information.
You will deposit in the court, no? This
Yes,
thing,
ma'am.
not like this. But why did you file a original TD?
Please, Lord.
Why did you file the original TD?
But this is the procedure followed, not here. This DD will be credited to.
No. First you have to file application, then we permit you to.
That application I have filed, not. No,
That IA 1/25.
application is put up, not.
IA 1/25.
Yes, not.
application
This IA is filed.
To deposit the.
Yes.
We will not pass out the application, but it is application. That is update. Now we may give it back. After passing them. We will give it back to deposit with them to the registry. That was not required to file.
Let's say this on 12/12/22. This court had directed the appellants to deposit a sum of rupees 3 lakhs before this court within 4 weeks. The said amount has not been deposited. The memo has been filed. Memo dated 7/1/2025 has been filed on 15/1/2025, stating that whereby the appellant has produced, has submitted a DD for 3 lakhs. DD dated 6/12/25. Hearing number 910564. Drawn on the State Bank of India for an amount of 3 lakhs. What about interest?
Interest was not.
Well,
I was directed to pay only 3 lakhs. Interest was not direct. Sorry.
we said 4 weeks also. That's right.
I'm sorry. But you say poor farmer, not.
The council makes a request that the said amount of, the said DD be allowed to be deposited in the registry of the court. Full stop. The DD as annexed at page 2 shall be returned back to the counsel for the appellant. Appellants who shall deposit the said DD within 2 weeks thereafter. IA 1 of 25 is allowed as is disposed of as allowed. They say that when the counsel for the respondent has no objection in that regard. Then you will say no. Petition in the ones. For the reasons stated in the affidavit and the legal counsel for the respondent. And return back. I hear this close. Just one minute. See, there are certain objections in your appeal.
Milords, the objections have been clear. Milords, the only thing is, Milords, the arbitrator has not been made a party, which we do not make.
No, they have pointed out some more objections. They show us that file, man.
Only one objection.
Respondent number 2 was the
Arbitrator. Much.
next.
15.
Still number 15, my lord, appearing for appellant, my lord, file application for recall the order dated 6/6/2023, my lord. I filed, my lord, better affidavit I have filed, my lord. 3/2/2023 I filed, my lord. Was dismissed before register protocol, my lord.
When was the this thing dismissed?
6/6/2023, my lord.
Have you now cleared the objections?
Lord, only one objection was there, my lord. I will not press that application, my lord.
Which that application?
The application number IA1 of IA2 of 2022, my lord.
Is the application?
IA for temporary injunction, my lord.
So the objection was only on that?
Yes, my lord. The correction of schedule to be stated correctly. I will not press that application, my lord.
See that. Objection.
Objection number 3, my lord.
IA 3/24.
24, my lord.
Schedule to be stated correctly.
Yes, my lord.
You filed the court fee.
Yes, my lord. Already filed the court fee of 1,57,925 rupees, my lord.
Did you file it?
Paid through DD, my lord.
ಯಾರು ಕೋರ್ಟ್ ಫೀ ಬಗ್ಗೆ ಏನು
Star has dismissed it.
Yes, my lord.
When did you file the court fee?
Now to verify, up to paid through DD, my lord.
I have filed a fresh IA for injunction.
Yes, my lord. Now the subsequent development has been taken place, my lord. On 9/11/2024, the respondent number 3 tried to take a position from the appellants, my lord. That time we came to know that that the appeal has been dismissed for non-prosecution.
Yes. When did you file the court fee?
I will verify, my lord. I will verify.
Verify that, because
Yes.
that objection, whether you have cleared it or not, we want to see it.
I'll verify, my lord, because I have paid the DD, my lord. I'll verify. I will verify, my lord.
In terms of the order of this court dated dated
7/1/2020.
7/1/25, the Eastern affidavit has been filed to IA number 1/25 on a specific query whether the objections as put by the registry have been cleared. The learner counsel for the appellant seeks some time to make his submissions in that regard. His request we notify.
Much good.
7th of April,
Much good.
till number 16.
For the appellants, my lord.
Respondents,
The
one.
appeal, my lord, is in respect of the dismissal of the suit for 12 sites carved out of Schedule A properties. I now have 4 applications before your lordship, which is in respect of 2 sites, sites number 92 and 93. My 4 applications, my lord, in sequence are IA1 of 2024 for mandatory injunction, IA2 for 2024 for an order not to alienate, order directing the respondents not to alienate, IA3 of 2024 for status quo in respect of site.
Any IAs are there?
There are 4 IAs before your lordships today.
4.
Yes, ma'am.
Are the numbers?
1, 2, 3, and 4 of 24.
What is for 1?
1 is for mandatory injunction to restore status quo ante in site numbers 92 and 93.
Right number?
92 and 93.
And what about the other second?
IA2 is for an order direct.
Is the idea for?
Is for the order directing them not to alienate or create third-party interests in the same sites, 92 and 93. IA number 3 is status quo in respect of site number 93. And IA4 of 2024, which ought to have been numbered first, my lord, is, my lord.
2 and 3 are same.
I'll just explain the difference, my lord.
About 4?
4 is an IA for impleadment, which ought to have come first, my lord, of
Treatment of?
proposed respondent numbers 12 to 15. All prayers in IA numbers 1, 2, and 3 are sought for against the proposed respondents.
All.
Yes, my lord. I'll just explain.
All these IAs?
I'll just explain, my lord. What has happened here?
Submission before, if I may be permitted. This honorable court on 17/3/2023 has rejected the very same kind of applications and has given a finding that the alienations was made by the father and husband of the appellants, and they were much prior to 2012/2024. Thereby, the purchasers cannot be injuncted. This is the wording used in the orders. So the purchasers cannot be injuncted. That is the respondents herein.
To explain.
So thereby, since there is an order already subsisting, these IAs are not maintainable is my humble submission. With regard to proposed respondent number 4,
May I just be,
left to the court.
12 to 15 are also subsequent purchasers?
no, may I just be permitted to explain, my lord? R4, that is respondent number 4, my father had sold site numbers 92 and 93 to respondent number 1 on 13/3/2004. I maintain OS 4033 of 2006, my lord, in respect of 27 sites in Schedule A property and 1 house property in which is Schedule B property.
How
Now-
many Schedule A?
Schedule A is totally 27 sites, out of which the list is in respect of 20 sites. During the pendency of this suit, my lord, R1, respondent number 1, sells site number 92 to proposed respondent number 14 under a sale deed dated 27/6/2016. This comes to be marked as Exhibit P79, my lord, in the suit. Thereafter, judgment and decree is passed on 3/11/2022. The categorical finding in the suit is that Schedule A and Schedule B properties are joint family properties of the plaintiffs and respondent number 4. The finding also, my lord, on issue number 9 is that the suit was within limitation. The suit is decreed in respect of 8 sites. In respect of 12 sites, which includes 92 and 93, the suit came to be dismissed. I prefer an appeal, my lord, against the judgment and decree in respect of these 12 sites alone. The appeal comes to be admitted on 18/2/2023. It is admitted on 18th of February. Thereafter, my lord, on 17th of March, my application for stay is rejected on the ground that all of the sale deeds in respect of the 12 sites were after 2012-2004.
Prior to 2020.
Sorry, prior to 2012-2004, and that is the reason why my application was rejected. Now, my lord, because my appeal is admitted, my case is before this honorable court in terms of merits, because I will be able to demonstrate, my lord, that explanation to Section 6 of the Hindu Succession Act carved out a co-partnership right in respect of daughters as early as 1994. The sales of site numbers 92 and 93 are in 2003, subsequent to 1994. Now, my lord would see that the sale of site number 92 was in any case a lispendent sale. So the title would be dependent upon the outcome of this appeal.
Now tell us one thing.
Yes, ma'am.
All alienation took place prior to 2012-24?
My lord, with respect to 92 and 93, I'll explain, my lord. 92 and 93 were on prior to December 2004, no doubt. But in Karnataka, the Karnataka amendment to Section 6 of the Hindu Succession Act had already vested co-partnership right in daughter.
The challenge that honorable.
My lord, I challenged it. I took it in an SLP before the Honorable Supreme Court, and the Honorable Supreme Court was pleased to dismiss my SLP. My lord, but my lord would just note the subsequent events.
But
After-
anything you are claiming will amount to variation in this order?
No, I'll just establish I'll just make 2 further submissions, my lord. After the appeal comes to be admitted on 18 February 2023, there are site number 93 is sold to proposed respondent number 12 in August of 2023. Site that is then mortgaged to a private finance agency, not a bank. It's to an Pirimal Finance in November, site number 93. And site number 92 is gifted by proposed respondent number 14 to his wife in November of 2023. All of these are after the admission of my appeal. Now, these are lispendent sales, my lord. And the validity of the title that has passed would depend upon the outcome of the appeal. Now, my submission.
Who has sold these properties to the
My lord, in
proposed respondents?
site number 1 was sold, site number 92 and 93 were both, the first sales were by respondent number 1. Now, my submission is, my lord, that the prima facie finding, wide order dated 17/3/2023, was that I am not entitled to the benefit of interim protection for the reason that these sales are after before 2012-2004. Now, my lord would see 2 things. One is that the finding that Schedule A and Schedule B properties are joint family properties has never been impugned by the respondents. They have not,
On to
yes, my lord.
any relief which you are seeking will have a bearing on this 17-3 or 23 order.
I am no doubt in an awkward position on these applications, my lord, but if my submission is that 92 is,
Are these people, this 12 to 15, they have purchased the property from respondent number 1, 2, 3?
No, only one.
respondent one, only respondent number one.
And interestingly,
My
they
lord would see my
included the
situation. What
schedule
is
of all the sites, which they couldn't get on an earlier occasion and which when the interim order was rejected. Now they have included the entire schedule under their application
My lord would
and they
see,
seek respondents. And what happens? They are trying to force themselves. So schedule claimed under IA.
What's defendant number 4?
my father.
Father. And, okay. So if that be so,
My lord,
how can you maintain a similar application?
my lord, my only submission is this. This is this is a first appeal. It's a statutory appeal. My lord would see.
Yeah. All these people who have sold, 1, 2, 3 have sold, yeah, one has sold. One has sold.
Only two sites, respondent number one has sold.
Now, that was rejected in the interim order in your favor, only on the ground, all these transactions, alienations had taken place by your father prior to 2012-2004.
My lord would see the untenable situation I'm in here because what is,
Oh, no.
no, my only submission is this, my lord. My appeal comes to be admitted. My appeal is limited, my lord. My appeal is limited to the sales that have happened in respect of these 12 sites. The findings in respect of my suit being in time.
Right, ma'am, you may succeed.
My lord.
Today we are only considering with the interim order. Tell us one thing.
My lord.
These 12 to 15 have sold, have brought it from respondent number 1.
Respondent number one.
When the respondent number 1.
One was not injuncted.
Exactly.
My lord would only see one, the one piquant situation over here, which is that I was dispossessed in 92. I'm not re-arguing.
Respondent number 1 was not injuncted. How would you claim a better benefit? What 12 and 15?
My one submission, my lord, is that at least in the light of the fact that I have an impleadment application, notice may go to two respondent because they may become, my lord, at least let them have notice of the fact that this appeal is pending.
We don't know very well. We can, if that is the impleadment, we will seek it. What
My,
you say on
my lord,
I have no objection with taking notice on respondents. I am not.
see their rights
appearing
also.
on-
Dependents will come in for them. We don't know.
my lord, the only submission is no doubt I had no interim protection against respondent number one, but the scope of the appeal, my lord, is limited. What ought to have happened, my lord, is that the appeal itself ought to have been dismissed if my interim prayer was being dismissed in respect of those 12 sites, because the scope.
You want that way?
No.
You will say so.
No. My submission is this, my lord. If in the alternate, may I ask that the appeal itself may be heard and disposed of finally? Because if there are equities, third-party rights that are continuously created in the sites, then the admission of my appeal would ultimately burden this honorable court, but give me no a fair outcome.
Supreme Court has upheld this.
My lord, in that case, what had happened was I unfortunately cannot go behind the decree.
So you will withdraw 1, 2, 3.
No, my submission is this, my lord. IA number 3 of 2024 is a vacant site. IA number 2 of 2024, that is in respect of site number 92. Within the appeal period, my lord, immediately after my suit was decreed. My suit was decreed on 3rd of November.
Anything which will flow from order dated 17/3/2023 or anything granted would be in variation with that order. We will not look into it.
My lord, if my lord would be pleased to fix a date for hearing of the appeal on merits,
We'll see.
then I will not press my applications.
You don't want impleadment of 12 to 15.
My only submission is that if that were to delay disposal of the appeal, then I will not press my applications if my lord would fix some date and take my appeal.
To take a call.
My anxiety and apprehension here, my lord, is that the more third-party rights are created during the pendency of this appeal.
So, in any case,
My lord.
let's assume we put the appeal for hearing.
My lord,
You will not press the sale which has taken place against in favor of 12 to 15.
my lord, but the fact is, if I'm able to succeed in the appeal against respondent number 1, then those are subsequent sales, my lord.
We don't know.
But if I were to succeed, my lord, then those sales would go.
You to take a call, then you want to withdraw all this?
My lord would pass it over. I'll take instructions from my client. My client is present. I'll take instructions.
Just say pass over.
Obliged.
Seventeen. Prakash Angadi.
National Highway matter, my lords,
Yes.
on the point of limitation, my lords. The matter has been adjourned on 17/3, similar.
Yes, what are your submissions?
The matter is pending before the Supreme Court on the point of.
Also same issue,
Please, my lords.
as we have been informed that the issue which arises for consideration in this appeal is pending consideration before the Supreme Court. We note, are the connected matters?
Please, my lords.
There are connected appeals, huh?
Please, my lords.
What is the date?
17/3, my lords. 17/3,
17th of
March.
Eighteen, Shri Vijay Kumar.
Appear for the respondent in this matter.
This is a suit for partition. We are defendants 1 and 2. Now the final decree proceedings are going on. I made an application for stay of at least the drawing of a final decree proceedings. Still the appeal is the drawing of a final decree. Usually, my lord,
this is within the family, no?
yes, my lord.
Lord, legal entitlement.
The
Lord.
mother-in-law is there.
My lord, she is 81 years old now. She is unable to enjoy the fruits of the decree, my lord. She is only asking for a share in what the son held, my lord. In fact, it has already come out in the deposition that, my lord, the appellant herself
Son got the share
is self-acquired properties, my lord.
for his acquisition.
And I'm asking only for the share of my son, 1/3 share in the son. That is also
Entitled to the share.
share of the son. Under section 8, my lord, I am the class 1 legal heir. What I am asking for, my lord, is that it went for mediation, my lord. They refused even to, my lord, make a reasonable offering. My lord, what I am saying is,
Other legal heirs other than these, the lineage from your son?
my lord, my son, my lord, the respondent's son passed away. The appellant is the wife, and there is a son, my lord, who has attained majority just now. My lord, I am not asking for a piece of land or an inch of land from the share of the appellant. I am only asking, as I fall under the class 1 legal heir, my lord. My entitlement, my lord, by operation of law, my lord, I should get. My lord, there is.
Yes, what do you say?
My lord, what I would like to tell your lordship at this point in time is this, my lord. The appeal is not yet admitted. Your lordships may hear the matter. We tried our best to get into a resolution mode. That did not happen. And subsequently, I come on record. There was a previous counsel in November, I came on record after the previous counsel retired. I don't know what has transpired prior to that. Your lordships could kindly admit and formally, your lordships may admit the matter. Grant an order. I request your lordships to.
Lord, may I make a submission? Lord? Your lordship may kindly see the last 2 hearings. I have filed 2 IAs. My lord, what is happening is the appellant, my lord, left, right, and center, she is, my lord, renting out the properties. She is leasing properties. My lord, my share is being enjoyed by her. I make an application. This honorable court.
What do you say?
I will file my. We file.
Rent she is getting for this share also. How much rent she is getting? Is she?
I will place it on record, my lord, all those details with a.
1/3, my lord. 1/3 and 1/6.
No, not
1/6 in 3 properties. 5 properties, my lord. 1/6, my lord, in 3 properties.
I will do one thing, my lord. I'll file my objections.
Let him file reply.
Yes, my lord. I'll do
Let
that.
him file a reply, my lord. Lord, let a date be fixed, my lord, because she's 81 years old.
Yes. No difficulty. No difficulty.
No, my IA is 1 of 20 and 2 of 24, my lord. Where there is a direction to the respondent, appellant to file his objections.
I'll file it, my lord.
1 and 2 of 24.
1 of 24 and 2 of 24.
Please, my lord.
1 of 24 and 2 of 24.
Can you, Mr. share one more copy because I don't have.
I will.
because I don't find it in the record.
Respondent. Notice, so and so accept notice for the appellants, non-applicants, reply be filed within 4 weeks, rejoinder within 2 weeks thereafter, list after 6 weeks.
Greatly obliged, ma'am.
My lord, that final decree proceedings are going on. Could there be some interim order? Stage is to hear appointment of a commissioner.
Has been filed, appointment of
Commissioner.
commissioner, there is a dispute, my lord. It is not going anywhere. My lord,
Therefore,
this
my
may
lord,
kindly be heard and disposed of, my lord. We will not,
because that is on
Will not take any
21
steps
to
there. I will-
2025.
please, please,
Yes.
please,
Grateful.
please.
That could be done.
The identical submission made by the council for the parties that the trial court be directed that that the final orders, the final decree proceedings be not passed. We direct so it is clarified that the trial court can hold the proceeding but shall not pass a final order
Please,
in the final decree proceedings
greatly obliged, my lord.
till the next date of hearing.
Grateful.
17-4,
Greatly obliged.
Grateful.
19,
One, two, copies.
Lord, had listed this.
Yes, come.
Lord, I have a copy of the award. Lord,
You have seen
what?
first.
My lord had a question that,
No,
whether
all these
26
appeals, 19, 20, 19, 20, 21 and 22 relates to the same village, same notice.
Please.
Show us.
Lord had put a question to me. That
Now, what is the submission you are making? Yesterday, we were on this submission.
that section 3G or 26, which is applicable. Because the award has, my lord, may kindly come to, the page numbers are at the downside.
What is this you have filed?
This is the award copy,
Award proceedings.
award proceedings
Okay.
of my village. Regarding to my village,
Dodda Siddhavanalli.
Dodda Siddhavan.
Ah.
So my lord, kindly come to page number 6, my lord. Whether 26 is applicable or 3G is applicable is the one question that. Page number 6, at the bottom of the page. Award per section 3G1. Ministry of Road Transport and Highways has prima facie decided that all awards compensation made on after 1/1/2015 for acquisition of land under NH Act 1956 will be as per the first schedule of RFCTLARR Act 2013. That is first submission, my lord. Because only limited scope of 3G is now, my lord. Just to send notice and notice to the interested person and award inquiry. Only that, my lord. My lord,
Just show that, ma'am. This 2013 Act.
my lord, also the National Highway Authorities Acts have also issued a notification to that effect. Whether 26 is applicable or 3G is applicable. That is a letter by the Ministry of Road Transport and Highways. My lord, in that document, kindly 5.8 be looked into. Point number 5.8. That is 185th. It is a serial of, it is a huge document where NHAI gives out the rules on to how to acquire the land. My lord, 5.8 maybe in page number 185 of 195. Not May I read, my lord?
Who appears for NHAI?
It has to go.
Huh?
Notice has to go.
Notice has to go
Not yet
because it's
ordered.
arbitral proceedings.
Where is the Shah?
My lord, may I read, my lord?
We'll just pass over the matter. We want some, just call her,
Please,
just ask her to come.
please.
So it's all four matters, right? You think all
23, Shri Jagadish.
When I appear for the respondents, caveator,
Yes.
and you have it at 2:30, madam.
Pardon?
I appear for the caveator,
Yes.
and you have it at 2:30, madam. I'll come in person,
Well, 2:30.
please.
24. 24 also.
24 also, both are one and the same.
2:30.
25, Shri Prasad BS.
Prasad DS. The petition has been noted. Needful is done.
Yes.
Ready?
What is this?
The process memo, what has to be done? The needful has been done. Use the mic. Use the mic. Mic use ಮಾಡಿ ಮಾತಾಡ್ರಿ. Process. Mic on ಮಾಡಿ.
Equal methods.
ಹೇಳಿ ಮಾತಾಡಿ.
The needful has been done, my lords. The process memo has been done.
Process memo.
What process memo? Have you issued notice on this?
Yes.
Missing the PO. Issue notice
Connected matters.
for first time.
25.
Connected matter.
Connected, are they connected? Okay. They're being listed together.
Yes, sir.
When? Last time. Not previously. Are they connected?
Yes, my lords.
They say that issue notice. But what happened? You did not deposit the process fee. Let notice be issued.
Today,
in
yes, he said he filed.
Form number 196 of 2021. On the basis of the process fee said to have been deposited by the council for the appellant today, the registry.
24, 4. 26 adjourn. 27.
Appear for the respondent.
Appear for the appellant.
Lords, the connected 27 and 27.1. Connected matters arising out of the same order passed under section 34. Lords, the last, I have to file I undertaken to file my wakalat in 27. I have still not filed my wakalat, my lords. I've still not received it from my client.
For 27.1.
27.1 is my appeal.
Verify.
Lords, and last time your lordships directed us to file our synopsis and judgments. If your lordships could grant us 2 weeks, we'll file that and argue the matter on the next date.
They say that for the parties, this needs some time to file written submissions in both the actions. We file within 6 weeks. Along with what they want to rely upon. Additionally, the council, Mr. M.K. Philippe shall file his wakalat for the respondent, for all the respondents.
There's only one respondent. The other respondents are arbitrators.
15-4,
So very grateful.
28, remand.
For the petition, my lord. But in this matter, we have filed the synopsis, my lord, notes of argument.
Yeah, now,
Direction.
we have not filed, my lords, we will file it.
It's a very short matter, my lord, only we are. Please.
You ready? Okay, we pass over.
Very
Just come back.
Great.
My lords, I'm sorry, I'm so sorry. My apologies. Can this matter be tomorrow, my lords? I have, there is one bereavement. Therefore, tomorrow, my lords.
My lords, wait, tomorrow, my lords.
We'll give you a date.
There's another problem we are facing. This matter before the learned arbitrator, my lord, practically we have completed the matter. And for 29 years, only 2 months have been extended. And out of which around 15-20 days is already over.
But the period expired 12 months, much.
Expired, my lord. It has been extended only for a period of 2 months that we are challenging. Therefore, in the meanwhile, my lord, my request is if Lordship may kindly.
Months only extended.
Yes,
Proceedings are not complete.
it is completed. Of course, there are a couple of orders which we have challenged. No, not yet.
But
Not
final arguments are to take place, man. It's posted for final.
This is 29A petition.
No. This application, there was one particular issue, my lord, which was subjected for arbitral proceedings, my lord. That they filed a memo retracting it after having agreed to subject the issue for arbitration, my lord. So on that question, whether they could retract after once the arbitration is proceeded.
Has been rejected is
For referral to.
Well, so section 8 application was filed before the commercial court, my lords. We were the plaintiffs, they were the defendants. They were defendant number 2, my lords. They have filed IA number 3 under section 8 under the, and in the relief was to dismiss the suit. But nevertheless, section 8 claiming that,
the plaintiff.
yes, my lords, we were the plaintiffs.
They filed the application.
Yes, my lords, the application,
Dismissed.
yes, my lords.
And
Now
the
it is under
claimant-
challenge before your lordship.
That's
It has come under challenge before your lordship.
Are under the impression, are there any proceedings pending before the arbitrator?
My lords, that is separate, my lords. There are proceedings, but not related to this dispute. But the contention they are
This
taking
issue.
is, this issue will.
That 2 months would be relevant for this.
I will submit, my lord. I will submit. Because that particular issue with regard to the policy, my lord, that issue also relates to the dispute between the partners.
This arises from section 8, dismissal of section 8. Has nothing to do with the proceedings
No.
pending before arbitrator.
Yes.
My lord, that so far as that is concerned, we filed an application because the reason before the learned arbitrator, they filed a memo saying that before the particular issue of policy, they submitted, we will subject it for this proceedings.
It's not a 29A,
No, not
Not the
29.
challenge under 20.
No, not
It is
29.
not.
section 8.
It's section 8.
Section 8. A short it, may I request, my lord.
What happened to the suit? What
It's
is the-
That
stayed here.
suit was posted for plaintiff evidence, but then there's a stay in this
Stay in
matter.
this.
Okay, what was the suit about?
The suit was a declaration suit saying that the policy was issued by defendant number 1, not defendant number 2, seeking a declaration that that said policy is null and void. Or there is an alternative relief, my lords. If it is held valid, they have to pay the money for it.
Therefore, they filed an apply memo before the learned arbitrator saying that this issue is between the partners, which is already before the learned arbitrator. It can be resolved. That was the memo they
That is
filed.
not- that
We
is not the sub-
consented.
We hear this matter for some time earlier.
Yes,
we-
please, my lord. Your lordship was pleased to hear. I have argued.
Not in depth, not in depth.
Oh, well,
It's not.
just give it, we'll come back after lunch.
My lord, after-
Yeah, she-
I can seek for an indulgence. Serial number 37 is a state appeal, my lord. I need some time in that matter. Umesh MN.
Just wait.
Please, please.
May-
Serial number 47, I have informed the other side, my lord.
You appear for?
Appellant.
I appear for the respondent. The
Pardon?
date may kindly be given.
What did you say?
Date may be fixed.
The request of counsel for the appellant be notified.
Short date.
26. 3/4,
May I make a
3rd of April.
serial number 46, my lord. We have to file our written submissions and all that.
For appellant.
We have not yet filed it. We'll file it by next week.
You appear for the respondent.
Appellant, respondent, yes, madam.
I'm for the appellant, she's for us. I've informed,
You have filed your submissions.
Yes, my lords.
respondents have filed, my lord. We have to file.
We have served them the copy as well.
Counsel for the appellant says that the submission shall be filed within 6 weeks. We notify all.
15/4,
Please. Great.
From the
30, sir.
30.
Serial number 30.
Appear for. But this is a petition and review of order passed by this honorable court under section 37. This honorable court wanted to know whether review is maintainable against order under 37. Good, Calcutta, full bench of Calcutta High Court in a section 9 petition which was dealt by the court, which was allowed and review was filed before the court. And in the context of review petition under section 9, the Calcutta, full bench of the Calcutta High Court has held that it is a court, therefore a proceedings before court, review petition is maintainable. That is the full bench judgment of the. You last may kindly see para number 9 and 10 and para 56. Para 9 and 10. It was argued that the said act that is referring to arbitration and being a consolidating and amending act, it is a complete code in itself. The said act does not confer any right of review, and it was argued that the right to seek review being a substantive right, unless it is specifically conferred, it must be deemed to be excluded. The Learned Counsel also relied upon Section 5 of the said act. According to the Learned Counsel, Section 5 makes it clear that in the matters governing Part 1 of the said act, judicial authorities are restrained from intervening in matters except where it is so provided. It was therefore argued that there was no express provision for review, and by reason of the provision of Section 5 of the act, the right to review is clearly excluded. It is also urged that exercise of the power under Section 9 of the act is a power which is to be exercised in the aid of arbitral process. As such, the provision of Section 5 of the act is clearly attracted in connection with any proceedings under the Section 9 of the said act. Learned Counsel for the review petitioner also raised various contentions in order to substantiate that the petition for review is maintainable. The Learned Counsel submitted that the said act may be a complete code for arbitral law, but same is not complete code for procedure, which is to be followed by the court in deciding matter which come before it. As such, the court should follow the normal procedure of a civil court while deciding a proceeding under the said act. It was also submitted by the learned counsel for the petitioner that the review by the civil court of its own order in a proceeding under the said act has not been excluded either expressly or by necessary implication. It was also stated that the civil procedure is applicable to courts as defined under section 2E of the said act. In view of the said definition, the right to review of a civil court proceedings is also available in the instant case. Various decisions have been cited on behalf of the parties. Last time I kindly see the case law is discussed, and thereafter in para 56, court has held that review petition is maintainable. Last paragraph. Madam, here, madam, what happened is, since from 1996, I am before the court and I was excluded from the court only on the procedural grounds. But what happened is, I was a successful bidder and I have executed work to the extent of agreement quantity in a railway contract. Please, please.
Review of which order?
Review of section 37 order passed by this. Here, the court has relied upon the submission of the railways that amount is deducted due to vitiation clause which is made applicable. My lord, the vitiation clause itself was not available in the contract, and they referred, what has been referred by the railways is variation clause which is available in the contract. Therefore, I was the
Still suppose 34 gold, there is no patent illegality.
But non-existent clause is relied upon to deduct my dues, man, legitimate dues. Man. Therefore, that is a.
See, we are in a different regime.
But this is section 30.
It's not like an appeal in the civil court where a review would be applicable, where there is an apparent, error on the face of the record. Those things would be available here.
But here, what happened is, you will also kindly come to para 18 of the judgment, of the page 35.
Let's see where is the section this judgment deals with, of which review is being sought. Which paragraph?
Para 18 of.
The impugned order?
Please.
Okay.
This court, in para 18 has had a reading of this agreement. What was extracted in para 17 is variation in quantity. It is not a vitiation clause which they said under which amount has been deducted. Variation is entirely different, where the engineering.
What does the order say, paragraph 8?
A reading of this agreement in the background of the pleadings and the absence of any arguments adduced before the court on this point, entertaining a new ground of challenge is not justifiable while exercising the power under section 37(1)(c) of the Act. It is well settled principle that scope of scrutiny and interference with the court under section the error relates to interpretation of the contract by the arbitrator is an error within the jurisdiction, and such an error is not amenable to correction by the courts. But this is the finding. Clause itself is not there in the agreement is my case.
What was your claim?
My claim is towards work done quantities. I have claimed 77.
Which is that claim? Show us the claim.
From my lord, that
Show us from the review petition.
my lord, that award is not a part of.
Appreciate without award being there, tell us.
I will give the copies.
Where is your main petition, review petition? Where is 37 petition? Is 37 appeal here?
But order made under 37 is enclosed.
Where is, show us which, against which claim you have made this submission?
Claim,
Show us the award.
please, madam. Award, item number 1 of the award, my lord, is regarding work done quantities.
Show us, where is that? Show us.
Please, madam.
We don't know what does 34 court says. We don't know.
Well, 30,
what the arbitrator says. We don't know what does the claim was made.
please, madam, I will,
Give us that.
please.
We have the arbitration law. Yes.
My lord, that is, that claim is towards work done quantities claimed by the claimant. My lord, out of that amount, railways have deducted a sum of rupees 53 lakhs, saying that vitiation is applicable to the contract.
Yes.
Listen, the clause which was relied by the railways for deducting the amount is variation in quantities. But what they have done is they have applied a vitiation clause which was there for a few years in the railway agreement. I am showing this clause only for the purpose of understanding. This was extracted in a judgment. You last may kindly see the vitiation clause, how it reads.
Also say vitiate.
Well, no, that is entirely different. The context under which in the variation clause, the word vitiation is used is entirely under a different question. And vitiation clause per se reads like this. Your lordship may kindly see this for a moment. Vitiation clause is extracted in.
What was the claim? Your claim is 31 lakhs have not been paid to you.
Yes, madam.
Because it stood vitiated.
Yes, madam. That's what they said. Vitiation. But
And it's your case also.
no, madam, my case is vitiation clause was not there in the contract itself.
Your claim. What was claim number 1?
Madam, claim number 1 is for agreement.
Claim number 1,
That was there in.
right? Just read it. Read it.
The claimant states that the value of the work done statement given by the respondent to the High Court wide affidavit number dated 9/9/96 confirmed that it was rupees 88,77,780. The payment was made only to an extent of 51,86,000 and the balance amount of 36,91,475 is due from the railways. The respondents have represented that the amount as per the final measurement recorded in the final bill due to the contractor is 83,07,575. From this, vitiation amount of rupees 31,15,008 has been deducted. Therefore, the amount due to the contractor is 51,95,500, which has been paid. Amount paid through CC bill number so and so. The balance paid under FCC is 2 lakh, which shows that the work done has been settled in full by the administration. The claimant has no dispute regarding the revised calculation given by the administration. It is seen from the variation statement filed with the High Court that the value indicated in the column work is tentative since the final measurement of the work done is yet to be recorded. This shows that the variation statement filed with the High Court is not final statement which can be relied upon for any payments to be made by the contractor. The claimant contended that the deduction made towards vitiation is unjust and arbitrary. The respondents have contended that clause 2.1 of the special condition of contract clearly state that the variation in quantity should in no way affect or vitiate the contract or the character thereof, and the stipulation of vitiation has to be kept in mind for all variation and will have overriding effect over the contractual clause from 2.3 to 2.5 governing the variation of quantities in the agreement during execution. They have also drawn reference to the TC minute where abnormal rates quoted by the tenderer have been noted and stipulation made for confining the agreement quantity during execution of the work. The arbitrators have examined all aspects and are inclined to agree with the respondent, especially in a contract where highly abnormal rates have been quoted by the contractor for earthwork, item number 5A and B, C, which are also main cause for vitiation. Therefore, arbitral tribunal is the view that no compensation is due to the claimant against claim number 1. That is their finding. Well, here,
Thing of the this court is, you did not, both of you did not urge this point of variation or vitiation.
Vitiation is not there in the agreement is our contention.
Okay.
The respondents have said, referring to variation clause, they said that vitiation is available in the contract. That is their contention. But vitiation as a clause is not there in the agreement itself. Agreement is available with me.
What the clause says is 2.1.
2.1, yes, madam.
Change in the quantities will not vitiate.
Vitiate the contract, madam. That is all it says. Here,
Vitiate the contract.
madam, here the vitiation clause, your last may kindly see in the judgment I have given just now. You last may read for a moment. Vitiation clause is entirely different. It says if there is a difference in the rates quoted by L1, L2, L3, L4,
calculation will be made on the basis of rates quoted by all the tenderers and lowest will be paid. That is the vitiation clause. I just now I have given one judgment.
But did you urge this point
My lord,
for 34 code?
yes, my lord, that's, 34 court, what happened, my lord, the council was, did not represent the matter before the court. My lord,
It's no ground.
what,
That's the finding.
my lord, that,
Both the parties did not urge this.
the
Both the party did not urge this.
court has said, court relied upon, clause 2.1.
What prevailed upon this court was that both the party did not urge this.
It did not urge, and I have, court further said in 37 that I have raised a fresh ground of, in 37, that is the,
So what is wrong with that?
my lord, this is not a fresh one, this was there in my ground number J 34.
Which
My lord, this was,
not urged?
I was prepared, what happened, my lord, the council was without trace, he was left. He has left the practice, my lord. Therefore, I was prevented from representing before the court.
We are in a review jurisdiction.
My lord, here,
Please, you will hear the court. We are in a review jurisdiction. There is a finding by this court saying that none of the parties have urged this. Is there any error apparent? And you concede to that there was no ground raised on this
no,
or ground raised but not urged.
ground raised but not urged, that is the.
And there is the error apparent. There is no error apparent, it's a fact.
But section, ground number J relates to vitiation clause, not applicable is my case. But it was erroneously said that variation clause is the vitiation clause.
That is, it is, just see this paragraph 18A, reading of this agreement in the background of this. Entertaining a new ground of challenge is not justifiable.
But that's what, but
Exercising power under 37(1)(c).
please, here, your lordship may kindly see that the section 34 petition as well as the objection filed. I have extracted in my grounds, my lord, page. But your lordship may kindly see, I have.
We will not. Where was the occasion for 34 court to look into it? Where was the occasion? See, at least prima facie, our view is review in 37 or 34. We are in a different, it's not a normal appeal where on an apparent everything need to be entertained.
But since from.
We will not go into that. What this court has held is, it was not urged, and that's a fact.
Just for a moment, you last may kindly see my 34 petition, ground number J one.
Yeah, you have pleaded.
Pleaded, man.
But not urged.
But in a similar case, what happened in the same.
Let's be very clear. We will not enlarge. We will not.
But this is a work done quantity, man. That's for this.
Limited. 37 is furthermore limited. We are in a review jurisdiction.
But this is, since 1996, my fate, you last me kindly say, this was even before a railway zone was made in Karnataka. It was, this work was done in the year 1996. At that time, the railway zone was in Hyderabad. I filed a original suit before the civil court for not to call the tender for they wanted to terminate and call the tender. I went to the civil court. At that time, final measurement was done and quantities were worked out at 83 lakhs. Thereafter, my petition was dismissed because of arbitration clause. Thereafter, my lord, I have come before the court in the arbitration, but.
Where is that award? Just take that. Just show us the award. So your claim was for variation in the quantities.
The deducted part in the variation of quantity should be paid to me. That is
Right.
That's
Right, yes. There was X amount, X was the quantities in the tender. It is X plus Y, that Y you are seeking. Yes, that's right. That was rejected.
That was rejected. It is towards work done quantity. My lord, you last may kindly see for a moment the vitiation clause, how it reads. My lord, no, for academic purpose, your lordship may see how it reads the. That judgment you lost.
We will see in a better case possible. Just take this. Want to first press this review? Want to press this?
Please, I have done this.
This is a review petition filed by the petitioner. Filed by the appellant seeking review of the order passed by this court on 8th April 21 in MFA 40 of 2016. Whereby this, which the said appeal, the appeal is an appeal under section 37 1 of the Arbitration and Litigation Act 1996, challenging order dated 26/9/2015, passed by the 10 additional city civil and sessions judge Bengaluru, dismissing the suit which was filed under section 34 of the of 1996, challenging the award. The review has been filed on a limited ground. Limited ground to contending that paragraph J of the appeal under section 37, which reads as under page 33. Which reads as under has been erroneously not considered and also has been overlooked as the ground J relates to denial of the claim of the appellant for variation in quantities and not a claim based on clause 2.1 of the agreement and not based on, just say that, and not based on a stipulation and not based on a stipulation and not based on a plea that the variation in quantities shall vitiate the contract or alter the contract thereof, alter the character thereof, or entitle the contractor to damages or compensation. The suffice to state that this court in the aforesaid order has in paragraph (16), 17 and 18 and 19 stated as under. Suffice to state, the conclusion of this court is also that in the absence of any arguments adduced before the trial court on this point, no new ground of challenge can be entertained while exercising power under section 37 of the Act of 1996. During the course of hearing, the learned counsel for the appellant did concede that though ground J was pleaded, but the same was not urged while arguing the petition under section 34 of the Act of 1996. If that be so, we do not see that the conclusion drawn by this court in paragraph 18 above, is an error apparent on the face of the record for us to continue with the review petition. The review petition being without merit is dismissed. Just give it back. Dismiss. Next.
Appeal number 31. Shekhar Shetty.
Plaintiff's appeal. Brief facts leading up to this matter is that the respondent is a developer who had assigned some construction work, implementation works to the appellant. And appellant had implemented those works on behalf of the respondent. In respect of the running bills, which according to the appellants remained unpaid, the appellant instituted a suit for recovery of 2.4 crores with an interest. The matter was placed before the commercial court at Bangalore. And while the matter was under consideration, the respondents entered appearance and filed the written statement, original written statement on 14/2/2017. And also the issues were settled on 21/7/2017. I'm troubling my lords with the dates because at a subsequent date, they come up with a counterclaim that is on 29/8/2017. They come up with a counterclaim in 2017, asking for taking up a contention that we have made some excess payment to them and we are entitled to, and for some delay, they are entitled to some damages. My first contention before the commercial court or also before this honorable court, two components are involved in this. One thing is raising of the counterclaim after the settlement of the issues. In fact, this question was raised before this honorable court due to divergent of decisions referred to a coordinate bench of this honorable court, wherein it has come to a conclusion after the trial has commenced, no counterclaim can be presented in the suit. And also the similar question was placed before the apex court. Both the compilations of the memo are placed on record before this honorable court, where the honorable Supreme Court also has summarized the fact. There's no question of entertaining any counterclaim after the settlement. So there is fundamentally an error in admitting. And second aspect of the matter, the counterclaim was based solely on the grounds of delay in completion of the project. Admitted facts on record is in 2013 end, the project has been completed. The project has been handed over to them. And 2019, they coming with a counterclaim is hopelessly barred by limitation. There is no limitation for the counterclaim to be accepted also by the commercial court. The third aspect of the matter, my lords, Section 55 of the Indian Contract Act. If a person chooses to accept performance beyond the time fixed under the contract, he disentitles himself to seek for a compensation on that count. And these bars were there, these points have been urged and placed on record. And there is an admission to the extent of constructions that I put up in the unpaid bills. But unfortunately, the commercial court has rejected my claim and also partially decreed the claim put forth by the respondent as a counterclaim, and accordingly decreed the suit for 44,84,000. Initially, there was a mistake in the calculation and the higher amount was decreed. We have sought for a rectification and it has been rectified. So the appellant is before the honorable court to consider all this material on record, which has been completely ignored by the commercial and completely contrary to bar of limitation, Section 50, and nothing has been considered in proper perspective. And the learned trial judges held, since you are issued a running bill, he is entitled to claim. That was not his cause. His cause was my delay. Every time I delayed from the schedule, his cause arose. At least on the date of delivery of the project, the cause ended over there. That was the date of completion. So these aspects.
So the date of the completion of the project?
13th, December 2013. The final bill statement was in 2014. The final bill statement, Exhibit P9, was in 2014.
When did you invoke the arbitration?
It is not an arbitration, my lord, original suit. 28/10/2016.
That's your filing of the suit? Or
Yes, yes, my filing of the suit, ma'am.
was the counterclaim filed?
29/8/2019.
28th February 2017.
Counterclaim?
Please, my lords.
I think 29/8/19.
Did 17 or 19?
19. 21/11/2000, sorry, 29/8/2019 was the counterclaim.
29/8. That was the date when it was allowed. What my learned friend is allowed.
Okay, you want the date of application? Application was 3/1/18. 3/1/18, they make an application.
Their counterclaim.
A counterclaim was brought in by way of amendment. They filed an amendment application on 3/1/18.
Or making part of the written statement.
Yes.
When did they do it?
They filed an application, if I'm correct, 3/1/18. 3/1/18.
So it
Three or
could have
two,
been
doesn't
before-
matter.
It's around 3/1/18.
When was that, pardon?
No, it was actually 2. I said 2 and 3 doesn't make a difference.
No, 3/1/18.
Yes, application. Allowed on 5/8/19.
Correct, that's correct.
5/8.
5/8/19 allowed.
Yes, please.
Amendment sought for incorporating the counterclaim also.
Counterclaim was incorporated on 29/8/19. 29/8/19.
So, but in any case,
Yes, please.
according to you, final bill, when was the final bill paid?
It is final bill, final area assessment was done in 2015.
Huh?
2014, fine,
Ah.
P9.
That's right.
Yes.
So their claim, counterclaim is excess payment.
Their counterclaim is,
Excess payment is against the final bill.
no payments were made. Area statement was made in 2000, after the completion of the project. In 2013, I handed over the property to them. In 2014, they made area measurement. Since I claimed there is an excess measurement, then what work was allotted to
When
me?
was the measurement made?
Measurement was made in 2014.
So no payment made after?
No payment was made.
When was the last payment made?
Last payment was made well prior to 2013 itself.
And when did you raise the final bill also?
P9. Just a moment.
As per the pleadings, my lords.
8/2/2015,
page 73. PW1 in his cross-examination reports that the last running bill was issued on 8/7/2015.
Final bill,
Please, my lords. Last running bill,
running bill.
running bill.
But that must be the final bill. There is no bill thereafter.
No, man.
When was the last payment? made?
And area statement was reconciled and I had confirmed to that on 8/12/2004, 14, sorry. 8/12/2014.
How can that be? See, there was a further bill you raised.
Not the further bill, on that only. That amount was not released to me.
According to Mr. Shetty, final bill was running bill is 8/7/2015.
According to PW1's cross-examination,
I don't find from it.
that is
Because
page
This is the
73.
area statement issued by them.
Will depend upon when was the last payment made. This is
Yes.
from the perspective whether your claims were right. There was no limitation against you.
No.
There was none. Very well. Insofar as they are concerned, possibly we have to see, because according to them, their case is excess payment.
Yes.
That must be after reconciliation, they realized that, oh, there is a payment excess which has been made to you.
Yes.
They made a counterclaim. When was that measurement made?
No, that counterclaim, in fact, excess payment is an incidental fact they submitted. What primarily they say is there was a timeline schedule fixed for you to complete the project. You did not meet the deadline. Go for the delay, and also they make a stray incident saying quality, but there is nothing on that. But
On the other hand.
in principally on delay.
Heads also.
Yes, please.
Okay.
On delay. And it's an admitted fact on record that in 2013, the project has completed. And when I deliver my humble submission is when I deliver the project to them, the delay ceases to continue. That was the time they should have called for. I issued a legal notice, no response, no claims were made. From the date of the project completion, delivery, no allegations were made about all this delay. There has been an acceptance of the
How
performance.
does the court deals with this? limitation. So we are first on the issue of limitation on their counterclaim.
Yes, please.
Now your claims, all claims were rejected,
All claims are
their
rejected,
counterclaim allowed.
allowed. Allowed, not totally. They asked for 3.5 crores, 44 lakhs is allowed.
What extent?
Yes.
Now let's see the,
My lord would kindly consider
let's see the reasoning now.
yes. I'll take my notes. Ink page 66, the judgment, impugned judgment, page 47. My lord. Paragraph 83, my lord.
Paragraph 80.
83.
Yes.
May I please read? Additional issue number 2, that is so there is a post amendment. The plaintiff is contending that the counterclaim raised by the defendant is barred by limitation. PW on the cross-examination has deposed that the last running bill was issued on 8/7/15 and the letter of intent stipulates that the defect liability period is 12 months after the completion of the work, which would expire on 8/7/16. The counterclaim was made by the defendant by way of amendment to the written statement by virtue of order dated 5/8/19, passed on IA and order 6 rule 17 on 2/1/18. Thus, the counterclaim made by the defendant is within period of limitation. Accordingly, issue number 2, additional issue number 2 is answered in the negative. So, for this, my humble submission to my lords is me issuing a running bill, how does it give him a cause for delay compensation? In fact, to say that the retention amount of 1 year or whatever, they had a 5% retention, that defect liability period was there. There was no cause for that.
Defect liability period, we don't know whether the trial court is right on this. Defect liability period is 12 months after the final completion.
Yes.
Final completion was when?
2013 December.
13 December, so 12 months, it will not be for him to, dear Mr. Shetty, what do you say on this? See, on paragraph 83.
Please,
let's look at it, read it in a perspective. The plaintiff contending this. PW in his cross-examination has deposed the last running bill was issued on 8/7/2015. By whom? By them.
By them, correct,
It will not endure to your benefit.
correct.
For against you, it started running for whatever it's worth.
No, the question is, my lords, when do we come to know excess payment is made? After reconciliation of all the work done.
The reconciliation done.
So therefore, my lord, only after they made a claim of further payment of 8/7/2015, subsequently we reconciled the bills.
But that's not the reasoning given. You see further.
No, okay, please, my lord.
12 months after completion. Now, this is another important.
So the question-
Issued on 8/7.
That is independent, and that is independent. Let's assume, remove that sentence also, my lord. Assuming 8/7/2015 is there, the question is whether I have to pay this bill or not is a question which arises for consideration.
Right.
Then assuming if I'm liable to pay, I'll reconcile my bill. If I've already paid in excess to him, the question of paying him further money does not arise.
Did you come to know that you have paid excess? And
Well,
at what time?
let's
Is it
assume
after
we-
reconciliation or even before that?
After he made a claim against us, my lord.
So that claim is primarily after 8/7/2015.
Correct, has to be.
When did that reconciliation? Who pleaded reconciliation? Tell us. See, where is the court considering this aspect of reconciliation? He only says two things.
My lord,
8/7/2015.
the question,
What he says is, it is inuring to your benefit, you will come within limitation.
is like this, my lord.
That,
My lord, the principle of limitation hit both way for both the parties, my lord. If he can't make a claim, neither can I make a counter claim with one aspect. The question is limitation is whether I have to pay me my money or I am entitled to seek for refund.
See, let's assume for a moment, even claim, counter claim, possibly you can argue, once the suit has been filed, there is a counter claim which arises. But even counter claim need to be within limitation or not?
Therefore, my lord, assuming I'm not before, my learned friend is before, if he is there not able to show this appeal is not.
But there is no issue for him that his claims are,
No, no, the issue of limitation, the court can take up always whether the claim is barred by limitation is the first issue.
but the court has, it appears, the court has not taken into that. But court has allowed your counterclaims, overruling his plea of
No.
limitation.
Your Lordship's are right, my lord. The short question would be, my lords, in this case is, was I liable to pay him certain amount? The court says we are not liable to pay certain amounts. Out of the total amount, what we have sought to claim, my lord, under two headings.
There is one more reasoning given. See 83 last line.
83 lakh.
The claim was made by the defendant by way of an amendment to the written statement by virtue of order dated 5/8/2019 passed on this. Now, what he's saying is, you have filed earlier a written statement.
Please, my lords.
You did not include your counterclaim. You sought an amendment of the written statement to include your counterclaim. It is the date on which this amendment was allowed in 2019 that is making your counterclaim within limitation.
Well, it goes back to date of application, not to the date of written statement. It relates back to the date of my application.
Relate back according to you.
Please.
It must relate back.
Okay.
But that's not the reasoning given by him.
We are before your lordships, my lord. Ultimately, my lords, the reasoning is.
On 2018 would be time barred.
How far that could be
My lords,
old good, Mr. Shetty.
my lords, this is a appeal against a commercial suit, my lords. Ultimately, on the basis of evidence, the question, ultimately, the point will boil down to the fact whether I am liable to pay him money or he is liable to pay me money.
Suppose he was to succeed on the ground of limitation.
If he was about that's a question of fact, which question of fact and law, which your lordship will consider. Your lordship may kindly see the deposition, even according to him, my lord, the question. So therefore, my lord, if he is making a claim, assuming he had not made any claim, it got over in 2013, everything was reconciled. I wake up and make a claim. That's not the case. Even according to him, his right bill was running bill, which was in the month of July of 2015. If that is the case, so the question of my limitation doesn't run at all, my lord. If I'm able to convince. So my excess payment would arise when he makes demand of payment, the reconciliation, because he.
No, but you will not reconcile your accounts to show that, look here, I have paid excess to him. You would independently do without waiting for a suit from.
Assume I'm not done in this case, my lord. So therefore,
That's the reason we are saying, if you had done reconciliation, let's assume in 2013 itself, you did not raise any issue.
So therefore, the fact that the moment he filed the plaint, I said, okay, you have made it a claim, let me go into my account, whether I have to pay you or no. So I have to defend my case. Your lordship may kindly say, I have to defend my case. When I'm defending my case, I'll say that, no, you're making a claim is unjust. In fact, you are liable to pay me. My lord, your lordship may kindly see if an unjust or a claim which is abuse, is not maintainable. Can't I say that, no, I'm not only not liable to pay you, you have to pay me? And especially when he raises a bill in 2015, assuming my learned friend had kept quiet in 2013, for the purpose of limitation, he says 2013. For filing the suit, he says 2016. He can't have both ways, my lord. If he says it is delivered in 2013, assuming limitation is not there, how could he file a suit in 2016?
But I don't know how far this.
Reasoning, I bow down to your lordship with regard to the reasoning.
When the counterclaim was made by the defendant by way of an amendment to the written statement by virtue of order dated this, passed on this.
So the question.
What he's saying is, my allowing this is making your claims within time.
No.
The amendment which I have allowed.
No, the question is, my lord, how a period of 3 years will be counted from which date is the question, my lord. So.
No, he says 2000, when we allowed it till 2019, that means all your counterclaims are within time. That's what he's saying. What have you pleaded insofar the limitation is concerned? Show us.
Your lordship, the proposed amendment is introduced on 2nd January 2018 and permitted on 5/1/2018. It's a statement of fact, my lord. The question of limitation mandatory to be considered by the court even in the absence of a plea in accordance with Section 3 of the Limitation Act, which applies to this case. In the present case, specific issue has been taken and the issue has been, the defect liability period and the retention period has no relevance for the demand of penalty or excess. Hence, the finding arrived at the issue of limitation is contrary to the admitted fact and error apparent on the face of the record, which requires to be reviewed and rectified. Even on the record values, the amount arrived is erroneous in the judgment, and in respect of the same, separate application has been filed. In the light of the foregoing facts, in view of the error apparent on the record to bring the impugned judgment in consonance facts and applicable law, it is just as necessary to review the judgment dated 21st. That was this was rejected, correct? Correct.
Where is your written statement? Where is your written statement to the counterclaim?
It's not part of this. It's not in the.
Is it there on record, your written statement?
Written statement is not on record.
Written statement, the plaint is not.
Just say that, no, but it's not on record. None of the pleadings are there on record.
Not on
Pleadings are
record.
not clear.
Just say that you file your paper book,
Yeah,
or we call for the TCR.
yes, TCR may kindly.
The TCR will requisition before the next date. Just for your.
The thing for the interim of stay.
We want to see what is your fiction taken.
Yes.
And what is their response? He has summed up the limitation only in one paragraph,
Yes,
3 lines. We want to know, did the reconciliation aspect came? It possibly, reconciliation can be a cause for them.
yes.
Say that, oh, look here, we have made reconciliation, now I am overpaid you. Then that may be a cause for them to make a counterclaim, or maybe file a suit, whatever they want to do.
Only one submission in this aspect. The counterclaim is in fact not based on an excess payment. What they have in fact come forward to say is due to a delay in the.
Both
completion of the
excess
project.
payment and penalty. Excess payment is 2 crores 15 lakhs and penalty for delay is 1 crore 28 lakhs.
They wanted.
For the delay, you could have otherwise also claimed.
You could have,
One project was
Manoj,
open, you did not claim.
just because I did not claim, he makes unjust claim. I'll say, okay, now that you want to, let us sort out the issue.
Cannot
No,
be
no,
accepted.
no, the question is, my lords, if he had not raised a bill on 15 July 2015, if he had not raised, and he says it is completed in the year 2013,
Not have claimed the penalty.
my lord, that question would not have arisen. The fact that he says a continuous cause, bill is still pending.
But the cause starts running against you.
My lord,
It was due when reconciliation done, you realize, look, yeah, I paid excess, it starts running against.
no, no, my lord,
We will see. Let
we'll
the
see,
record-
please, please.
let the record.
Now the matter is tomorrow posted, the execution. Kindly an interim order of stay may kindly be granted for a limited
The
period.
execution is pending.
Yes, tomorrow. it's
No, no,
posted.
in terms of law, you have to deposit the money, let him deposit the money before.
Call the money, there's a money decree.
Money decree.
Now, perhaps it's barred by time and
So
also
that all,
at least some percentage,
Your
yes.
case, your case would be you have a prima facie, you will succeed, that's all. But still we are in a money decree, there is a decree. You deposit 75.
I am like,
Deposit 75%.
50%.
No.
50%.
75, please.
50%.
Maintain 75.
Considering the context of the case.
Unless there is a hard facts, we will see case to case basis, not otherwise. Tell us. Is there application for stay?
Yes, please.
Yes, say this, have you issue notice?
Give it.
Say issue notice. Who is briefing you, Mr.
Mahesh Chaudhary.
So,
Yeah,
Mr.
give it.
Chaudhary accept notice for the respondent,
give it.
maybe we'll stop, let the, admit, not admit, forget it. Admit that the trial court record the requisition before the next date of hearing, paper which be filed within 6 weeks. The counsel for the appellant states that the respondent has initiated execution proceedings and has filed an execution petition which is listed tomorrow before the executing court, subject to the appellant depositing 75% of the decreted amount computed as of today within 8 weeks with the Registrar General of this court. There shall be a stay of the impugned judgment decree dated 21/1/2023 as rectified on 21/11/23 in form OS number 25994 of 2016. 16, till the next date of hearing, the amount to be deposited shall be invested in an interest-bearing FDR of a nationalized bank with periodical renewals till further of this. Counsel for the parties will be at liberty to make the written submissions along with the judgment they want to rely upon within 8 weeks. List on.
17-4.
Please.
Yeah.
Next.
Serial number 32. From November.
What is this?
It is barred by limitation.
Claim for maintenance, my lord. Claim for building maintenance. Fine, of course, the claim was made and certain amounts are barred by time. I have given up that barred by time claim. Only I have restricted my claim for 3 years prior to the date of filing the petition at the rate of 5,500.
Was it a continuous cause of action?
Yes, my lord. Every month he'll have to pay the maintenance.
Oh, the maintenance charges
Yes,
for a
my lord.
housing society.
Yeah, yes, no, it's not society yet to be formed.
What do you say on that?
In regarding para 37 of the lower court judgment, Lordship may kindly see, in order to determine the point of limitation, it is necessary to refer to the following decision of this honorable
Just one. Where
Supreme.
is the claim petition? Where is your suit? Claim?
Suit, it's in the records.
So was it a suit for recovery?
Yes, my lord, suit for recovery,
How much?
about 17 lakhs, my lord. Security,
Tax, which period to which period, and when did you file the suit?
yeah, the suit was filed on 11/4/2023, my lord.
2023, for which period you made this 17 lakhs?
That is for 51 months of maintenance, plus 5 lakh rupees was given as a security deposit to the
What is the period? Date to which date?
51 months, my lord, that is.
Now, this 51 includes
These three,
6 months as well.
true, Miller, true.
Tell us one thing.
Yeah.
If 51 months, maintenance include 36 months.
You are
To that extent,
the finding given by the commercial court in page number 37, para number 37, page number 25. That is, my contention is the suit is barred by a limitation. In order to determine the point of limitation, it is necessary to refer to the following decision of the Honorable Supreme Court of India. That is Laos, yes, Supreme Court, 2022-135 Supreme Court of India in regarding versus cognizance of for extension of limitation. Paragraph 37.
37. Okay.
The present miscellaneous petition, you will also find out. The present petition, miscellaneous application has been filed by the Supreme Court of India. Advocates on record association in the context of the spread of the new variant of the COVID-19 and the drastic surge in the number of.
Will not you.
No, that is finding of the court. Then.
See on that Suomoto 3.
That is, yes, regarding further I will come. Your Lordship may kindly see in sub-para 4, page number 27, it is further clarified that the period of.
Understanding, his plea is this. He filed the suit on 11.
Finding of the trial court is sued by.
To us.
Yes.
He filed a suit on 11/4/23.
The defendant in para 40, the contention, the defendant is contending that the suit is barred by limitation. The defendant is contending that though no specific issue regarding the question of limitation is framed by the court, it is settled law that the court has to determine the question of limitation as to whether the suit was barred by limitation at the inception of suit as per section 3 of the Limitation Act, page para 41. The plaintiffs are contending that the cause of action to file the suit accrued to them on 11/6/2013. The date on which the joint JDA was entered into between the plaintiff and others. On 11/6/2013, the date on which supplementary agreement was entered.
28/7/2017, the date on which declaratory affidavit was executed by the defendant. 27/2017, the date on which the possession of two flats were handed over to the defendant. On 29/1/2022, the date on which the legal notice was issued to the defendant. On 4/2/2022, the date on which the reply notice was issued by the defendant, and subsequently, it is settled law that the issuance of notice of demand does not arrest the running of time to file a suit for recovery of money unless the defendant unequivocally acknowledges her liability. Para 43. As per the recitals of Exhibit P11 and the deposition of DW1 in the cross examination, it is evident that.
Just 1 minute. Come to page 17 of the appeal paper.
17.
Page 8 of the impugned order. You see paragraph 7.
7, yes.
Now read it.
The total amount.
When was the suit filed? Suit was filed on 11/4/23.
23, yes.
Okay. Now.
In para
Yes,
7.
read that paragraph.
The total amount, page number 8 in para 7.
Correct.
The total amount due by the defendant is to the sum of the tune of rupees 17,47,357 as shown in herein below. Rupees 5 lakhs being the refundable security deposit amount along with 18% interest per annum from 28/7/2017 to 28/3/2023.
He says 5 lakh is due and he is interest in, he is liable,
Yes.
he is entitled to 18% per annum from 17 to 23. Okay, and he says 10 lakhs odd. Very well, forget that. Come to B.
Rupees 3,71,500 being the arrears of maintenance amount payable to the plaintiff along with interest at 18% per annum from.
Just tell us something. You have to tell us.
Yes, ma'am.
The principal amount was for which period?
Principal as claimed in the suit was for the period mentioned 28/7/17 to 28/3/23.
That's interest you are seeking on the principal amount.
Principal amount, this month, Milord, 30, this total amount claim is for 51 months maintenance charges plus 5 lakhs, Milord.
Where are you claiming 51 months? Tell us. Where is that 51 months?
Now I have, as I stated, Milord, I have given up that I am restricting it to only this.
Please, your evermonth, please, for 51 months, I am due this amount. That's the principal amount. You don't make such a claim. You are conscious that you were due of 5 lakhs in 2017, 18% interest from 17.
I have given it, I consider that it is barred by time.
Where is your claim for 17 months? 51 months?
No such.
That is mentioned in B, Milord, that
B.
3,71,000 being the areas of maintenance amount payable to the plaintiff along with the interest. From
What is the interest period?
28/7/2017 to 23.
So what you are saying is,
From,
just one.
yes,
What you are saying is, in 17, you are entitled, you were liable to get 3,71,500. From 17 to 23, if you compute that amount at 18% per annum,
but
you are entitled to 7,47,000.
Milord, it was worded like that, but actually this is the amount including interest 3,71,500 is claimed.
Should say, my entitlement for the
True, Milord,
for this period, which includes 3 years preceding the filing of the suit, is this, and interest is this, which it appears you have not made any claim. You have not made any claim. We were under the impression you made a composite claim for 51 months, which breakup would include for the period 3 years preceding the filing of the suit. That's not the case. This amount is primarily for the amount payable in 2017, 5 lakhs and 3 lakhs, and interest thereof at 18%.
With the respect, Miller, it is not, so it is not so, Miller.
We don't know, we will go by the pleadings.
Miller.
You show us
Then,
one every month.
Miller, you will last grant me some time, I'll just go to the original pleadings, and because I am not the author of the original pleadings, therefore, I'll just go through it and I'll make submission. You'll last grant some short accommodation, so that.
Yes, see, we'll just show the ECR. According to you, what was the total areas to be paid for 15 months?
Three, 5,500 per month is the amount I claimed, Miller.
Now this 3,71,500
Yes, ma'am.
was for which period? Areas of maintenance. What is the break? What is the period?
That's why I request you also give me a short accommodation. I'll look into the pre, because that, and I'll make a submission on that.
$1,500 was the
Monthly maintenance claim.
monthly maintenance.
Yes, ma'am.
12 by 16. See, then this 371 will not include 3 years preceding the filing of the return suit.
That is, it's a filed by limitation, entire,
How?
that is his claim regarding, he filed that regarding, various,
You come to his paragraph B at page 18.
judgment.
Page 18, paragraph B, small b. Just show him, please. You have seen, you have the impugned order. His claim is 3,71,000.
71,000, yes, this is finding of the, that is, their plead, he's pleading.
Listen to us.
Yes.
The claim is 3,71,500.
Yes.
According to him, this amount is payable between 28/7/2017 to 28/3/2023.
Yes.
Okay?
Yes.
He filed the suit on 11th of April 2023. Okay? So what his submission is, this 3,71,000 includes maintenance for a period of 3 years preceding the filing of the suit. He can file a money claim within 3 years. So a part of this 371 was within limitation.
But he has not mentioned that,
That's the pleading. 3,71,500 being the areas of maintenance, amount payable to the plaintiffs along with interest at 18%.
but that has been not, shown in the trial court, commercial court
This is,
regarding this.
this is the trial court record. See the pleading. The
That,
plaint.
no such pleading is there.
Rejected it. He could have said very well. Part of it is beyond limitation, part would remain here.
Yes.
And to that extent, the suit would be maintainable.
That regard, I will, go through something and give a
Yes, yes,
week's time will be granted regarding that.
and what are the documents you have filed for the to show the maintenance?
Miller, I have produced the several document, the judge does not refer to any one of the documents.
The document you have filed.
Miller, exit P1 to P14 documents, Miller, development declaration of fees filed by the respondent, then registered defendant, orders, legal notice, copy of the postal acknowledgement, reply notice, computerized generated generated copy of the statement of accounts of PW1 issued by the Kotak Mahindra Bank. Receipt issued by the.
Did you file a fresh suit for the period post?
Yes, my lord, I preparing because the period is another 26 months over, therefore another few more months we will be filing it for the subsequent period.
Where have you given the breakup for? So that is his claim.
But
15 to 23, I want 3,17,000.
but that is the barred by limitation. That is my contention.
How?
That is, he claimed, your lordship may kindly see in the plaint, cause of action, page number 13.
Yes.
The cause of action for the suit arose on 11th June 2013, the date on which the joint development agreement was entered into between the plaintiffs and the defendant and others. On 11th June 2013, the date on which the supplementary agreement was entered, on 28th July 2017, the date on which declaratory affidavit was executed by the defendant. 28th July 2017, the date on which possession of the two flats were handed over to the defendant. 29/1/2022, the date on which the legal notice was issued to the defendant. On 4/2/22, the date on which the reply was issued. Here, on the basis of this cause of action on 28th July 2017, the present suit has been filed. In 2023.
When did he pay the last maintenance?
He has not paid maintenance at no point of time he has paid
From
maintenance.
which date he was entitled to, you were entitled to the maintenance?
17, my lord, 2017, that is 28/7/2017, on which date possession was given to them.
So that's the date.
Yes, my lord.
Okay. Yearly is how much? 6,600?
Yes, madam.
60,000?
60,600.
66,000.
Yes, madam, 66,000, true. And for 3 years, I have claimed 1,19,000.
But how much would be for 17 to 23? How much would be the total areas?
1 lakh, well, of course, for 17, it is that 3,71,500.
Is it the correct amount?
Yes, right.
51 months. 2,80,500.
So that's it. See, we need to allow this.
I will submit later. 1 week's time. I will give the pictures of that in short.
No, we will allow this. We'll allow in part.
No, you'll also kindly have it on next week. I will, in the meantime, I will submit. Hello, regarding that limitation, I will urge that
We
is
are
finding of the
convinced,
court.
We are convinced.
One I will research.
Okay. Oh, we will pass orders. We allow in part.
1 week, a week's time will be granted.
Come tomorrow.
Not tomorrow. I will discuss that my parties and I will.
Sorry.
A week's time, a week's time.
It's all right, please. Enough. Allow in part, we'll pass orders.
A week's
Okay.
time I will grant it.
Next.
Bill number 33, Shishu Kumar.
Right.
My lord, I appear for the appellant in this case.
Yes.
Lord, this is a 37 application challenging the order passed in 34 before the commercial court. This is regarding contract, my lord, of aerial survey to identify some mineral potential areas all over the country. It was divided into different blocks, and block number 1 and 4 has been awarded to the contractor. And there was a delay in submitting the deliverables as per the contract. Subsequently, the dispute was referred for arbitration, my lord. And the arbitral panel consisting of a panel of 3 arbitrators has been formed. And the award was pronounced by the panel, tribunal. And the penalty that has been deducted from the final bill was awarded as a claim number 1, along with the charges which were incurred by the contractor for extending the bank guarantee, my lord. So challenging the award, we have filed the petition before the commercial court under 34, pointing out the perversity in the arbitral award, because the evidence produced by us before the tribunal was not appreciated properly, and the interpretation of the contractual conditions of the agreement.
You file the complete award, arbitral record.
Please, arbitral record has not come, my lord.
Award is a.
Award is there, my lord. Award and the impugned order is also produced.
How much is the delay?
My lord, the delay is around.
Release condone.
10 days.
My lord, delay was condoned last time. Already condoned.
Already condoned.
You file the complete arbitral record before 34/4.
Please, my lord. It is all, my lord. Complete. My lord, I filed an IA for stay on the execution proceedings, my lord.
Execution.
We have filed stay. We have filed.
How much is the liability?
About 2 and odd crores.
2.5 crores, my lord.
What is that amount?
Yes.
What is the date in the
No,
execution?
there are 2 matters, my lord. There
There are 2 connected
there are
matters,
2
my lord.
connected matters.
Yes.
They relate to different blocks.
In the first matter, my lord, it is around 2.7 crores, my lord. And in the second matter, it is around 1.78 crores.
No, 2.34.
1.34 crores.
But what you said is ultimately money decree that is been.
And my lord, it comes from an arbitral award, which my lord stands on a slightly different footing, as the Honorable Supreme Court says.
What do you say? To take instruction, but we want, because the ultimate.
My lord, I'll take instructions, my lord.
Just say this, when is the date of hearing in the, this thing?
Execution.
On 15th.
15th, my lord.
15th of this. Just say this, let the trial court record the requisition, the counsel for the appellant presses for the stay as execution has been filed. Since there is already an award, in favor of the respondent, the appellant is liable to deposit the equitable amount as directed by the court, as shall be directed by the court. Learned counsel for the appellant seeks some time to take instruction.
Please, my lord.
Please request, just take an adjournment, Mr.
We will.
To a date beyond the date, we will take instruction. You take instructions.
Please, my lord.
Next.
My lord, give us a date.
Give us a.
5-3.
Yes.
5-3. Right. My lord, in the meanwhile, the respondent's name has undergone a change. My lord, can I just?
Application.
I'll file the application. My lord, I'll file my lord, it is their appeal. Can I file a memo to that effect, my lord? I'll serve a copy on my lord friend. I'll file it in the court registry.
One thing better would be supported by an affidavit.
Very well.
Right. File it, supported by an affidavit.
We'll do, my lord. Great.
34.
I appear for the applicant. Suit for recovery of money is filed. The plaintiff pleads that in 2006, he has advanced 2 crore 75 lakhs.
Yes.
The plaintiff pleads that he has advanced 2 crore 75 lakhs to the second defendant, one Hari Reddy, in the year 2006. He was made as second defendant in suit.
he expired in pendency of the suit. LRs were not brought on record and he was given up and his name is deleted. The suit abated.
Huh.
The suit abated against him. So the question of decreeing the suit further will not rise at all. That is one submission. Then currently what happened is on 7/12/2012, an agreement is stated to have been executed by the Hari Reddy.
For the respondent.
Respondent and no notice has not given.
The caveat of Shashank.
This is the caveat of it.
I have served the copy. Physically, I have served the copy. I have also signed the copy online.
Now, what is the urgency, Mr. Surana?
Tomorrow the execution is posted. I will file the paper book. Let the execution be postponed for some time. We will make a representation of the court.
How much decree?
Decree, the decree is, see, principal, it is like this, my lord. Suit against principal borrower is dismissed and suit against guarantor is decreed. That is impermissible in law. I will file the paper book in 2 weeks.
But did you inform the council about the date?
You have informed. A memo is served before posting.
Where is the endorsement telling him the date?
On the memo.
Have a look. We always say you should inform the caveat.
We have informed, we have served the copy of the caveat.
To us.
After the memo was moved, it was set upon the council.
No, date.
My lord wanted that
Date.
ninth memo was filed.
Say,
Pardon?
what does he say?
Ninth memo was filed. My lord was pleased to give the date as 5/2.
Correct.
On the same day, on 9th itself, after the date was given, it was served upon him.
After date given.
After the date was given. After my lord gave the date, my friend went and served it.
What has been received, we want that the date must be notified to the council. Generally, what happens is.
No, I follow,
Because the memo is
I don't stand on the, I don't stand footing. The matter is listed today. My friend is not there.
Just inform the council. We'll have it day after tomorrow or Monday.
Available, Monday, my lord.
Just say that there is no appearance for the caveat. We notify on Monday.
Shall I intimate him again by memo or not necessary? Very well,
He is here.
yes.
10-2.
He is the caveat.
I will do it, my lord.
Just take up those 4 cases.
Serial number 19, first door matter, Shri Amit Hegde.
Visha, these are, see, there are, maybe I don't know, there is 1-2 matter, there is no appearance for the NHA. See, we want to know an issue has arisen. Whether in acquisition of for NHAI, will section 26 of the Act of 2013 be applicable? Because it contemplates how the compensation need to be given under the Act of 19. What is being contended before us is, it's not 3GF or 3G5 or 3G7, but it would be 26 which will be applicable. That means all those consideration, relevant consideration under the new Act of 2013 would be applicable and not the considerations under NHAI Act.
Lord, only for determination after 1/1/2015, this act, right to fair, is made applicable to acquisition under NHA.
What do you mean by determination?
Determination of compensation by SLU.
Now, will that mean
So 3G5 will continue
to be applicable.
No, it would be applicable. There are two aspects of it. Are you saying that when it comes to determining the land value, although the land value parameters would be same for even under 2000 Act, 13 Act, and 2000 under the NHA Act?
No, my lord, there are difference.
What is the difference?
Difference. My lord, there is a solatium provided under right to fair 100% solatium. There is a multiplier.
We are not on solatium interest. We are not on solatium interest. Solatium interest, surely once a land, cost of the land is determined, surely it will add on to those. On solatium, because in view of tar same thing, it gets covered.
It gets covered.
That's right. It gets covered from back date, from the date of even.
That also
notification,
yesterday.
Much before 2015.
Application filed by NHI seeking clarification whether it should be applicable retrospectively or prospectively. That also decided yesterday.
That was decided.
Yesterday.
Saying
decided.
what?
Saying that
No.
from the day one.
Obviously, once they think there is a
Yes.
determination, there is a determination. So solatium, because ultimately what the court has held is a discriminatory.
Yes, yes.
So it will be solatium and this, which was not being
No,
given by the
my lord,
NHA.
my lord, again, my lord, solatium was 30% under LA Act. Now under right to fair, it is 100%.
100%.
Then
Fact
there are
to be-
multiplying factors.
To me, solatium and interest would be granted.
Yes, ma'am.
But what is being said is, what happened in one of the cases is, we are concerned with two villages. In one village, just hypothetically, it is 600 rupees per square feet, let's assume. Both the villages were part of the same notification. In the second village, the guidance value, the earlier guidance value was 600. In the second village, it was 250. They were not at par. Okay. What is being contended is, part of the same notification, two villages, there cannot be any two different yardsticks for compensation. That is for square feet. We are not, don't get into
Yes, yes,
solatium.
yes. My lord, so far, like that aspect, my lord, generally, my lord, SLO passes award village wise because each village has different guidelines value and sales taxes. So there is a possibility that.
That's
Yes.
what it appears to be. That's a justification given by the 34 court.
Yes, yes.
Wherein the guidance value itself is different.
Yes, yes, my lord.
So, but in any case, on solatium and interest, this would be applicable.
Yes, my lord.
Yes, now what do you say?
My lord, one aspect is that, my lord. Second aspect is that in the petition appeal itself, as the petitioners have produced two sale deeds, saying that there are different guideline values altogether and market value altogether. Only one sale deed is considered. The other sale deed is not considered because it is little higher at the value. The same is contended and that was not taken into consideration.
Show us in which matter?
My lord, at page number 32 of serial number 19. Just because it is less than 10 guntas. The extent is less than 10 guntas. That is why we are not considering the sale deed. That was the reason that was given here. That cannot be, my lord.
Which page?
Page number 32. Paragraph number 25. On careful perusal of the award. Award passed by SLAO and the award passed by the learned arbitrator. This court noticed that out of two sale deeds, the first sale deed dated 14/7/2015 was in respect of survey number 418 1B2, measuring 8.5 guntas, and as it was only in respect of 8.5 guntas, the learned SLAO has not considered the sale deed because of it is less than 10 guntas. And he has given proper reason for not considering it. My lord, this cannot be. Supreme Court has held that the extent will not matter. I have the judgment.
How much is the square feet?
My lord, the extent that my land,
No, what is the guidance value?
The nine guntas, how much is square feet?
What is the guidance value in the beginning?
My lord, this is 9 guntas. This is 6,95,000 for 9 guntas, which amounts to 30,88,000 for 1 acre. And here they have taken only 10 lakhs as lakhs for compensation as for 1 acre. That amounts to 30.88 lakhs. Be permitted to make one submission. The coordinate bench of this honorable court has already issued notice in in 3 of the appeals.
Pardon?
Coordinate bench of this honorable court has already issued three of the appeals notices for 3 of the appeals. It is filed by me.
No, with the same village.
Yes, my lord. There are 30 appeals which are filed. 3 of them are already noticed. I mean, the coordinate bench of this.
Do you have any idea, Mr.?
No, I have no idea.
My lord,
Where are those orders?
I shall give the number, my lord.
Any council appeal?
No, my lord. This
This
is
is the year of appeal.
same 2024, my lord. I shall give the number. I will produce the.
When was the appeal listed?
It was listed in November, my lord.
What is the date of hearing?
A date, that is, that I have to give it, my lord. I mean, I just had,
All these 4 petitions pertains to the same village?
same village, same acquisition. Notification. Same notification.
But given the date, we will have it on that.
My lord, the date was not given, only the notice was issued
Just say that
by the coordinate bench of this honorable.
at the request of counsel for the appellant, by stating that identical appeals relating to the condition and same villages. My issue notice issue. This issue notice. So who will accept, Ms. Shah? You will accept?
Let notice go to.
Notice
because,
go.
like, I mean, other matters, if one lawyer is engaged, like, let's same honor.
Respondent, so and so accept notice for R1.
My lord, respondent number
Just check.
Not R1.
3, my lord. Respondent number 3 is the arbitrator. The notice may be dispensed with.
Three arbitrator, so and so, let notice be issued to 1 and 2.
Please, my lord.
Just check up all the appeals.
I
competent?
Both are.
Just give a copy of the appeals to us.
Please, my lord.
In all the 4?
In all the 4. There are another 20 matters which we yet to be listed. Lord, 25.
What?
25.3, some of the matters are listed before this one.
25.3?
25.3.
25. So we
Or
are
I-
date, which are the dates?
Please, I shall give it.
But you say 25.3.
25.3 is, which came before this honorable court. Because of paucity of time, this honorable court posted for, the notice was not issued.
Next.
Thirty-five.
35, serial number 35.
Nanda. Huh? Is one more. Is one.
My lord, senior is appearing virtually.
Yes.
In this case, I appear for appellant, my lord.
Yes.
My lord, I think the voice is not audible. It was informed.
Yes.
My lord. I appear for appellant, my lord. This is the suit filed by the appellant herein for specific performance of the contract dated 26/12/2014. And the
Yes.
suit was dismissed against which this appeal is preferred. Before starting the merit of the appeal, I would like to bring to your lordship notice one point and argue that point with the leave of your lordship. So far as regular first appeal is concerned, matter of course it should be admitted. It cannot be dismissed at the stage of admission. This is my submission with the relevant provisions as well as the Supreme Court ruling. I will convince your lordship. Your lordship permits me.
Yes.
The lordship may be pleased to. First, your lordship, I will take your lot. Section 96 of the CPC. It is a provision and a statutory appeal, as your lordship knows.
Yes.
Save where otherwise expressly provided in the body of the code or any other law for the time being in force, an appeal shall lie from every decree passed by any court exercising the original jurisdiction to the court authorized to hear appeal from the decision of such court. An appeal may lie from the original decree passed ex parte. No appeal shall lie from the decree passed by the court with the consent of parties. No appeal shall, except the question of law from the decree on a suit of the nature of cognizable by court of small causes when the amount or value of the subject matter of the original suit does not exceed 10,000 rupees. Now, language use is shall. What is the prohibition for filing the appeal also is there. That's why if there is no other impediment, appeal shall hear and pass on a merit. Then I will take your lordship section 129
This shows that. No?
of CPC. I'll read it, my lord. Notwithstanding anything in this court, any high court, not being the court of judicial commission, may make such rules not inconsistent with the letter patent or order or other law, establishing it to regulate its own proceedings in the exercise of its original civil jurisdiction, and it shall think fit that nothing herein contained shall affect the validity of any such rules in the force of the commencement of this court. So, by virtue of this, Karnataka High Court has passed the Act and rules both. Now, the chapter 6 of 4, your lordship may be pleased to take. Chapter 4. Chapter 4, your lordship may be pleased to see.
Yes.
In addition to the powers of authorities conferred by this and other rules, the registrar shall have and exercise the following powers, subject to any general or special order made by this Chief Justice: to receive all the appeals, petitions, applications, and other proceedings presented to the court, to examine all such appeals, petitions, and other proceedings and safety himself, satisfy himself that the same have been presented within the time prescribed therefore, and for the proposed form contained in the particulars required by the law, and these rules are duly stamped and the proper court fee are accompanied by the necessary enforcement, and all the aspects comply all the provided law, and these rules applicable to their presentation, and on being so satisfied admit them.
What is the submission?
That your lordship may be the registrar himself has to admit it according to the Karnataka High Court rules. Your lordship later you have 5 in that same 5 your lordship may be pleased to see to admit all civil appeals and issue notice to the respondent.
That we will do it. That we will do it. But why this objection on your part? Why the submission on your part? You are the appellant.
Yes, that's what I am submitting. No, what I am submitting before your lordship. When such is the case, question of posting it for admission before the bench does not arise, and matter of course it should be admitted. That's all what I want to say. It is covered by decisions of the Supreme Court, 2 decisions against the Karnataka High Court itself.
Okay. Now, what is the position now insofar as the decree is concerned?
My lord, the appeal is filed with the plaintiff. Suit has been dismissed.
Yes.
My lord, the court has held that the agreement, the registered agreement entered into between the parties was a sham document. My lord, the parties are related to each other. The contention raised by the defendant before the court below was, it was a transaction entered into to support the plaintiff to obtain a financial help. He had arrived from Australia and said he had no funds at all. So he requested that an agreement be entered based upon which he'll approach financial institutions and raise loan based on that agreement. And my lord, the period that was mentioned was 2 years, 10 months for completion of the contract. And my lord, he kept quiet all the time. We were under the impression that he wants to use it. Later on, he gets issued a legal notice to say, you have received 1,59 lakhs by way of cash from me. Come forward and execute the sale deed. And he immediately filed the suit. We took up the contention. There was no consensus ad idem. No amount is paid by him. We had not agreed to sell the property. This was the only property available to me. So the question of what had been mentioned in the document as legal necessity did not arise. The court considered our objections, our evidence, and rejected the claim.
Just show the order sheets.
Now, first place, I would like to submit before your lordship.
One
If your
minute,
lordship
1
is,
minute, please. Yes,
your
ma'am.
lordship is convinced, if the matter should be admitted, matter of course as held by the Supreme Court, then there is nothing more to say admission. Otherwise, if your lordship does not agree with me, in
Just
spite of
say
Supreme
issue
Court
notice.
decisions, I will argue on merit. There's I have no objection.
So and so accept notice, admit. Let the trial court record be requisition, paper books be filed within 8 weeks. List of.
One submission, my lord. I asked for the stay, interim stay, not to alienate, not more than that.
My lord, insofar as
One submission also made, my lord. This
Was
file
there
came
this-
from other office. He said in trial court also there is a stay, but now I checked up, there is no
I
stay
will
at
not
all.
oppose that submission. In fact, I would say he has filed an affidavit. He has misled this.
That is what I am saying.
That there
The
is. a
other
stay.
office has
I
said
have
like that. We
the
have
order
heard it.
sheet
I
copy
said,
with
I am
me.
sorry.
In his
That's why I am
affidavit, he has
sorry.
sworn to
On
a
the basis
false
of
affidavit.
his statement, advocate statement, we prepared it. Now we find it. There's a mistake. That's why I felt, I'm sorry. I said, we are sorry. I am not claiming on that. But
Yes.
the Supreme
Yes.
Court said, my lord, in a matter that is specific
1
performance.
minute. What is the name? Mr. Shetty, just 1 minute. We have admitted the matter. We are calling for the TCR, paper books be filed. Insofar as your application for the stay is concerned, the counsel for the respondent says there was no stay before the court below.
That I agree.
Then,
don't
then we will
dispute.
leave it at that. Next
fact,
date, give the
He
date.
has filed a false affidavit to say on a particular date.
Not false. I said some other advocate who handed out the paper said, moment I came to know, I said, sorry, there is a
Okay,
mistake.
Mr. Shetty, thank you.
17-4, serial number
No,
36,
I mean,
36.
Happy for the opponent. It's a defendant's appeal. Suit for partition came to be decreed. Where I had purchased this property in the year 2004. I am the one of the property, this property. Now the respondents are going to execute the decree before the final decree proceedings before the court below.
Who is the other side?
Other side not had been first time coming up for admission. Whereas the suit properties or other suit scheduled properties are there, my lord. Leaving that property, only these two items has been filed for the partition and separate position. But earlier, the partition suit has been filed by the other family members. That suit came to be dismissed. Against
What
that,
is the position now before the court below?
where I had, court below, there was an interim order not to alienate the property. Now the suit is decreed. They are yet to file the execution, final decree proceedings before the court below.
They are yet to file, no?
Yes.
Just say issue notice both on appeal and the stay application. Returnable in first week of March. Next.
Trying our final decree proceedings may be state subject.
Come, let them come. We are giving a short date.
6-3.
The maintain status quo, where I am in cultivation of the property, it will again.
You are in possession of the property?
Yes, ma'am.
They have not filed execution?
Not.
They're giving short date. Next.
37, government advocate.
No.
37, government.
Pay for the respondent.
Yes.
It's a state appeal.
This is state appeal, no?
Yes, ma'am. In fact,
Yes,
in the
yeah,
morning,
they-
they moved for an adjournment.
At the request of counsel for the appellants, re-notify.
Three, four,
3-4. Great.
Next.
38. Serial number 38.
You have the appellant in this matter. my lords.
Yes, what is it?
My lords, this is a writ appeal in respect of a short service question, my lords. My lords, the respondent herein was a former employee of the appellant corporation. And my lords, after rendering services before the Karnataka Food and Civil Services Corporation, which is a separate state entity, he had joined the services of the appellant corporation. My lords, after his services came to an end and he retired, my lords, he had claimed that his pension also include the services rendered in the previous corporation. Now, my lords, the position that was taken by the appellant corporation was that the service rules of the appellant corporation do not envisage such previous service to be taken into account.
Is it a pensionable there?
My lords, it was.
Where was previously he was working?
My lords, he was working at the Karnataka Food and Civil Supplies Corporation Limited.
Is it a corporation? Is it an entity under the state or it's a state in itself?
It is not so, my lord.
Just 1 minute. Let's hear him.
My lords, it comes within the purview of the state, but my lords, we do not have instructions as to whether the previous service was pensionable or whether they were supposed to grant
Now,
pension.
what was the previous entity? What is the name? Supplies Corporation Limited.
Yes,
Okay,
my lords.
It's a sort of a public sector.
Yes.
Okay. Now, was that and now service in KPCL is a pensionable?
Yes, my lords.
It's
And
pensionable.
the pension is supposed to be calculated as per the pension scheme of the
Just
corporation.
1 minute.
Yes.
Was your service under the Civil Service Supplies Corporation a pensionable service?
I was a deputy from the state accounts department. I was in the state government.
What happened? You got absorbed?
No, I applied for the application for the Karnataka Power Corporation. When I was a deputation to the Karnataka Food and Civil Supplies.
Okay.
So I was a state account department.
Very
I
well.
was deputy for Food and Civil Supplies Corporation. Then I applied for the post of the accountant through proper channel.
Then were you absorbed in the Civil Service Corporation? Were you absorbed?
Yes, ma'am.
What happened to your previous service under the state?
State that they have forwarded, I have resigned
Forwarded
it.
to the.
I have resigned it with
So
proper permission.
So you technically resigned there and you got absorbed here.
Ah.
What were you paid when you retired from the Civil Service Supplies Corporation?
I was a first division clerk there.
No, where did you retire from?
No, retired from the state Karnataka Power Corporation.
Oh, he retired from you?
He retired.
Now, acha. And you got absorbed here in the Karnataka Power Corporation?
Not absorption, but I applied for through proper channel and I was taken fresh appointment in Karnataka.
Oh, that's a fresh appointment.
But through proper channel. There also pension was there.
Now, when you came here to the Power Corporation, what happened to your all the benefits under the state government and the Power Supplies Corporation?
As per KCSR 252B, the service rendered in the state government will count for the.
That's right, but that's in the state government.
That is statement.
But you came to the
There
civil
also-
supplies.
There also there is a provision. There is a provision.
Where?
Karnataka Power Corporation. I will look into it. Sir, will you please.
No,
see.
we are not on Karnataka Power Corporation. We are at the first stage. Before you came to Power Corporation, you came from state to the Civil Service Corporation.
Yes.
Okay? Now your past service in the.
I was deputation.
You will
from-
just listen to us. Your past service in the state was counted in the Civil Service Corporation?
Yes.
It was counted?
No, I was a deputation.
You did not absorb.
No, not absorption. I was a deputation to Food and Civil Supply Corporation from the state accountment. I applied through proper channel to the Karnataka Power Corporation.
Now, what does
Both
the
are-
single judge holds?
My lords,
Single
the-
judge holds, you count everything
Yes,
for the purpose of pension,
indeed.
including the state government, including the civil supplies, and the service here in KPCL.
And my lords, all liability on the appellant corporate.
No, he will make his contribution, whatever is contribution to be made by him,
Yes.
he will make it.
My lords, that's not, that's not there in the order. My lords,
Are you agreeable to that? Suppose he makes his, see, an employee need to make his contribution, whatever
Indeed.
contribution is.
Yes,
Okay, now we have to see the rules also.
yes.
If that obligation is there on his part, he will discharge it. But you will count everything for the purpose of pension when he retires.
My lords, the first difficulty, my lords, is that the rules of the corporation insofar as after he was appointed here, which was after he has resigned as in his previous position at the Civil Services Corporation, he joins the apparent corporation and that's a fresh appointment.
But tell us, you know what, technically,
Yes,
at least going by what submissions he had made, it was pensionable in the state government.
yes.
It was not pensionable in the Civil Service Corporation. He came on deputation. He did not get absorbed. While working in the Civil Service Corporation, he came to KPCL. So for all purposes, he is not a permanent employee of the Civil Service Corporation.
Yes,
His lien continues to be in the state government. Getting?
yes,
If lien is state government, he comes to civil service supplies, he comes to you as a fresh appointee, okay? And he retires from you. And your services is also pensionable.
yes.
So if see the continuity, initial appointment in a pensionable service, retirement is pensionable service. So he is seeking you, please count my service from that date. He is not a absorbed employee in the civil services.
Yes.
Civil service. If that be so, why not? What is wrong in that judgment?
My lords, the error, my lords, that we have pointed out, and this is, my lords, our first ground on which we've challenged this. My lords will find the impugned order on page 27 of the appeal.
Yes.
My lords, may I straight away just point to the holding in respect of the service rules, my lords, of the corporation. My lords, that, my lords, will find at page 48 onwards, my lords. In fact, my lords, may I just point to page 49.
40?
49 minutes. So, my lords, the learned single judge considers two questions. First is, my lords, as the respondent was just pointing out, in respect of whether there was proper permission in as far as Rule 252B of the CSR rules are concerned. Now, my lords, we have our reservations about its application to the corporation because insofar as the corporation is concerned, there is the pension scheme. And for calculation of the pension, for how it's paid and what is considered, the scheme is, my lords, it's all encompassing. So therefore, it doesn't need to refer to the CSR rules at all. Irrespective, my lords, let's just look at the finding on the rules of the corporation. So, my lords, that's at page 50. I'll just read from paragraph 19, my lords. Yet another factor to be noticed here, which fortifies this view of mine, is that the petitioner is entitled to the benefit of past service of the petitioner under Rule 10 of the pension rules. So, my lords, this is the corporation rules, which reads as follows. Now, my lords, Rule 10 applies to absorbed employees. In case of employees whose services have been absorbed in the corporation in public interest from central or state government and or organizations owned and controlled by governments, the service rendered in the respective organizations prior to absorption will be reckoned for computation of the qualifying service provided such employees were eligible for pension benefits in their parent organization, as though the service has been continued uninterrupted. Note 1, this provision will be applicable only to those who would be in service of the corporation on the date of introduction of these rules. Note 2, the pension calculated in the corporation for the period as reckoned above will be reduced by such quantum of pension the absorbed employee is eligible to receive from the government department / government organization from where he was transferred. Now, my lords, a plain reading of the provision would say that this applies only to absorbed employees and not in the present case. And my lords, the learned single judge acknowledges this to a certain extent. So my lords, paragraph 20, though this rule pertains to absorbed employees and may not apply stricto sensu to the petitioner, the intent of the rule is clear that the employees who had rendered past service in central or state organizations and also organizations owned and controlled by the state are entitled to reckon the past service they had rendered before absorption into the KPCL for the purposes of computation of qualifying service. Now, this, my lords, is the primary observation which we have filed this appeal against. Because, my lords, effectively, there is a rule which only applies insofar as absorbed employees are concerned. That, my lords, has been read.
Where is his appointment to the Civil Service Corporation?
My lords?
Where is his appointment
Yes.
in the Civil Service Corporation?
The date, my lords?
Where is the terms of appointment?
My lords, he was appointed, the appointment order is dated 18th December 1973.
And when did he retire from KPCL?
My lords, on 31st May 2000.
Did he, according to you,
Yes.
when he left KP, that Civil Service Corporation,
Yes.
has taken all the benefits from that corporation?
My lords, we do not have information on that because, my lords, interestingly, the respondent herein had sent us 2 representations. This was, my lords, first in 2004 and second in 2011. Now, my lords, at that point of time, we had called for a service register. Now, my lords, we were informed that the service register is not maintained after a certain point of time. And unfortunately, my lords, the respondent had approached the corporation in this regard quite belatedly. So the information we received was that the service records are not there. We don't have the register with us. And we informed this to the respondent. So, my lords, this was the context in which the first
So
round
he
of
came to KPSCL
Yes.
or this KPCL in 1974.
in 1974.
Pension scheme was introduced in 1982. 1982 pension scheme was
Where?
the Karnataka Power Corporation.
Very well. What is the position in the Civil Service Corporation?
Civil service was on deputation only.
Your
My-
deputation?
Only on deputation. My service is in the state accounts department.
There is, we got it, we got it. So you came while on, did your parent department give approval or
Yes.
forwarded your application for
Yes, yes,
KPCL?
definitely they have.
Where do you say so?
They have forwarded the application.
Where do you say so? You must show when you applied, when you are working in Civil Service Corporation, when you applied in KPCL, the application was routed through your parent department.
1 minute. I will clarify. See, I applied for the post of the accountant on, my application was forwarded by the state accounts, Karnataka Food and Civil Supplies. There are 2 things. One, Food and Civil Supplies, state government. Food and Civil Supplies Corporation is
Where were you working?
I was
Initial-
first working as the Food and Civil Supplies, state government.
Now,
my
who has forwarded your
My
application?
application forwarded by the state government Food and Civil Supplies,
To the KPCL?
KPC, and also marked the copy to state accounts department.
Then I think he is right. Then the learner see, it's like from one pensionable entity to other pensionable entity. KPCL Corporation, which may not be having a pensionable service, he was on deputation only, his lien was always with the state government.
My lords, can I just refer to this representation itself?
Sure.
Yes.
We wanted to see it. So for all purposes, who has forwarded this thing was the state government.
Yes. My lords,
Resignation was also accepted by the state government.
Then he's right.
my lords will find that at, my lords, page 71.
Previously, it was known as Mysore State Corporation.
For earlier it was a Mysore State. Mysore Power Corporation, then.
Yes.
See and mind it. And this letter, if you see on the right side of the top,
Yes,
Office of the Director, Food and Civil Supplies, Bangalore.
yes,
And this is the Department of Food and Civil Supplies under the state government,
yes.
as different from corporation,
My lords,
as different from corporation.
yes. My lords, there are observations in respect of that as well in the single judge's order, which, my lords, that pertains merely to the civil service rules as well as the interpretation. So, my lords, under 252 B, which my lords is referred to, wherein he says that resignation of an appointment to take up with proper permission another appointment, whether permanent or temporary, service in which counts in full or in part is not a resignation of public service. Yes.
This
Now, my
goes
lords,
against you.
my lords, the interpretation of this rule and how the learned single judge has interpreted it is our second ground, my lords. Because proper permission would mean that there is not just intimation of the resignation, we are also informed, my lords, we have also referred to, my lords, 2 judgments of this honorable court.
Young man, we will tell you this letter at page 75 answers your submission. I am sending herewith the application dated this of the above official in original for the post of accountant for consideration. So this application, his application to KPCL was routed through his parent department, that is the state government.
Yes.
If that be so, 252 clicks in.
My lords, the difficulty for us would be that insofar as the corporation's pension scheme is concerned and the corporation service rules are concerned, my lords, those operate independently. So, my lords, the KCSR's applicability would only be to an extent where there is either a lacuna or there is any sort of derogability. So, if, for instance, there is a rule which, my lords, the respondent will say that either applies or it does not, or there is silence in respect of a particular service. Now, my lords, this is a case where the past service that he is asking for, my lords, once there is no rule, my lords, our first submission is that.
Would you come over 252?
My lords, the fact is that 252 will not be automatically applicable.
Why not?
My lords, because the KCSR rules, as I stated, my lords, is something which will only apply in situations where the corporation does not have its own rules. So in a situation where, my lords, the corporation has its own
Very
service
well.
rules.
Let's meet it. Where is 252 reproduced? Which page? He has reproduced the 252.
At 46 minutes.
46. So let's go one by one. 46 is 252, resignation of an appointment to take up a proper permission. This is the state government rule.
Yes.
Okay. Another appointment, whether permanent temporary service, in which counts in full or part, is not a resignation of public service. So what does do mean? Interestingly, intent is when he is applying through his employer, he gets an appointment that must not be construed as a resignation. That means it is not a resignation which will forfeit his past service. No. Now come to the next rule of yours, KPCL rules. Now, 18, the contents of para 8 of note extracted above, introduced by KPCL, state that the scheme would be regulated on par with the state government rules and regulations in matter pertaining to pension, gratuity, benefit of extraordinary pension, rules of the state government, and GPA would automatically attract 252B of the KCSR, especially when there is no specific provision made in this regard.
My lords, para 8 of the note, which he refers to, my lords, in my respectful submission, my lords, there is no such reference because it does not. So, my lords, what that interpretation would mean is that in situations where there is the corporation's own rules in respect of a service matter of payment of pension, what services to be considered, my lords, this will not. So, para 8 of this note, which he refers to, my lords, I'll just take, my lords, through both of those.
See, 252 is clear.
252 is clear, my lords. My lords, that rule in and of itself exists. But the interpretation of that and how it would apply to a situation where the corporation has its own rules is where, my lords, our first ground is. My lords, may I just take you
We'll
to,
tell you, we'll
Yeah.
tell you how it works. It works like this. Obligation of the state government in his case is because of 252. When he gets appointed here in the KPCL, the state government will say, look here, he has worked for 8 years in my place. This is the contribution for 8 years to you, to the KPCL. That contribution is taken by the KPCL and it will be put in your kitty. You will not pay him for that service done by the state government. You will put in your kitty. When he is working with KPCL, when he retires, you will give that amount as a pension to him. That means effectively that 8 years of period in the state government gets counted for the purpose of his pension. That's how it works.
Please.
So
My
that's
lord-
how what has been done by the learner single.
My lord, 1 minute. I will give clarified. Page 166. There is a note, office note in the KPCL. There was a para
What
9.
do they say?
But the MD has been authorized by the board of its 90th meeting to frame the issues, rules, pension, DCRG pensions, paragraph 8 of the agenda. Item number 27 of the 90th board meeting may also be perused, wherein the contemplates regulation of the pension scheme on par with the state law. This is the office note. Where has been, MD has been
This
approved.
will not be. He has come through proper channel. He may have gone to the civil service, but ultimately when his application for KPCL was being considered, it was through proper channel by the approval of the state government. So state government will not treat his going to KPCL as a resignation, but will treat it because it was through proper channel. It will be his benefits in the state government gets protected. And that benefits they will give it to KPCL. If KPCL has not got the benefits, tell us one thing. When you joined KPCL, did your parent state government has contributed to your period when you were in the state government?
No.
That they should have done it.
my lords, and that's the difficulty today. Because the learned single judge, of course, doesn't address that point. So, my lords, if we look at the operative portion of the judgment, at paragraph 52,
Rule 252B applies to my case.
That we have understood. But who will contribute for the service in the state
But
government?
it is a less than 10 years. So the next, the KPCL has to contribute.
Which
That
one?
is pension.
Who?
KPCL, Karnataka Power Corporation, where I have retired.
No,
There
you are
are-
right. Who will contribute for that? How many years of service you put in the state government?
88 years.
So 8 years contribution, who will make?
That is the 252B.
Yes, what does 252D says?
That for purpose of pension, it is service will be continued.
It will
Continuous
be
service.
continued, but
Continuous service.
it will be continued, but contribution, who will make the contribution? Did you receive that 8 years?
8 years, nothing. I have not received anything.
You have not received?
Anything.
That they will contribute it, then only you will pay it.
my lords, that's the difficulty. Because, my lords, the learned single judge does not address that issue.
I know you are, possibly it was a non-issue.
Indeed, my lords, and if we look at my lords, paragraph 24, my lords, let me first just address paragraph 23.
See,
Which is the operative
was the state government a party?
No, my lords, it wasn't.
Is the state government here a party?
My lords, it's not because
He is, the additional chief secretary is here. Energy department. See, they should answer. Did they file any counter there before the learner single judge?
they were represented, my lords. We are.
What was
unaware
their
of the-
stand?
My lords, unfortunately, my lords, I don't have instructions on that because, my lords, the appeal was, my lords, I'm handling this matter only on the part.
Who has filed the pleadings before the learner single judge? You have the complete pleadings?
Pleadings we have, my lords.
Did they file a checkup and file those pleadings? We will look into it,
Please.
possibly.
Yes.
Today, what it appears to be, what can be your apprehension is this. For the period when he was not with you, he was in the state government, that liability has also been fastened upon you. That's right?
Yes.
Possibly we can put it to him that he says, even he did not get any benefits from the state government. So possibly we have to ask the state government for the period of 8 years, you should pay, they should pay to KPCL so that the period is counted. That's how it need to be. Just file those pleadings. Just say this.
The Karnataka Power Corporation is a state government owned corporation. It is not a, this one.
No.
Private. It is
No,
not.
no. For entity, for service conditions, there are two different entities. Corporation is regulated by its own regulations and state government by under own rules. That you would not. Just say that counsel for the appellants state that he shall file all the pleadings that were filed before he shall place on record all the pleading that were filed before the learner single judge within 3 weeks.
My lords, may I just make one submission? My lords, I note from the appeal papers, my lords, that the state department, which was R1 in the writ petition, my lords, is not a party. My lords, perhaps my lords, could I also just seek the indulgence to file an
just check
impleading
up.
application, my lords?
You just check up.
Yes.
Then we can, the states,
In the
district chief secretary is there, we can issue
Writ
notice.
petition, the state government was one of the parties.
That's right, we have seen that.
Yes.
Check up that.
Yes. My
Otherwise,
lords, on
we'll
the
issue
pleadings,
notice.
I'll just take
They have not
exceptions and I'll
pleaded-
file whatever is
They
necessary.
have not filed any pleading.
They were not, they did not.
Right. Definitely, there is no point in this.
Their
We'll
pleading
just
was-
confirm it. I'll confirm this, and my lords, whatever additional pleadings are there, I'll file that. My lords, just,
Okay.
in respect of my lords, the state department, my lords, if they could seek instruction, because effectively the question that
If there was some AGA here, we could have told him to take instructions.
my lords, could a notice be issued if possible? Otherwise, my lords, we can also file an impleadment application.
Then we will cut that, ma'am. Issue notice. Mr. What is your good name?
Lakshmi Narayan.
Mr. Lakshmi Narayana, the respondent number 1 is present in person, accept notice. Let notice be issued to respondent number 2. Returnable on. Just give it in April, ma'am.
15-4.
Public.
You are getting pension from KPCL?
Yes, I'm getting.
Continue to draw.
Obliged.
Still number 39, Javed.
Appearing for appellant notes.
Just give you dates.
Please, notes.
Just say due to paucity of time.
Division bench. Give the dates. Division bench.
Still number 30. Still number 39.
Lordship, division bench of the Honorable High Court, Delhi High Court, my lord, in similar this High Court's judgment, single judge's order was referred to before the division bench, and it was in favor of union. And the same.
What is the issue?
My lord, the multipurpose state policy, my lord, multipurpose state policy, trolley policy of the railways, my lord, regarding the shops, small shops in railway stations, my lord. The policy regarding renewal, whether it is automatic and whether the policy is.
See that, no, it's not possible.
9-4. Still number 40, Jayana.
In this month, madam, delegate, dealing madam.
We will give you the more convenient date. Not possible.
9-4,
Next.
41,
The March. No. Please don't clog the board. Next.
41, Jagdish Baliga.
Just say date,
15-4, 42, Prashant Chandra.
Paucity of time.
16-4, 43 to 47 urgent, 48 government advocate.
My lord, I appear for the respondent in the case. He was supposed to file the paper book. On the last occasion, your lordship directed that he must file the paper book. The only point is that he has not deposited 20 lakhs, which was ordered by this honorable court. When I move the contempt to court, they say, there is no direction that he must deposit, but he has undertaken. But yet, your lordship said, we'll take up the matter on merits and finish it off, provided he files a paper book. He has not done. Therefore, that point remains to be answered. Therefore, your lordship may kindly have it at a shortest possible date.
We will see.
Very well.
Just say the first week of April.
7-4,
Next.
49, government.
Ask the appellant to find the paper books. Not ready.
17-4, serial number 50, Shiv Kumar.
The appellant in this case, my lord, your lordship had protected me, my lord, till today. For because the execution proceedings were pending before.
So here's for the respondents.
Lord, the
Served
respondent,
and under.
Spend 2 to 4 dispense with,
please, my lord,
they
that
are preparing for one.
Only served.
served represented.
Just say despite service, there is no appearance for respondent number. We notify the appeal on. What is the interim order, Mr. Bhushan?
Lord, it was granted on 17/12 that, my lord, the executing court shall not precipitate, my lord, till the matter is heard before this honorable court.
The interim of the order dated 17/12/2024. Shall continue.
It says, my lord, it is to be on request made by the
No,
council.
just say this, the executing, despite service, there is no appearance for respondent number 1. The executing court shall adjourn the proceedings to a date beyond the date fixed by us in this appeal.
Please.
Just say that. Next.
21-4, 51 urgent, 52, Shri Ranganath Reddy.
Respondent.
Yes, just say because of paucity.
21-4,
That's all, no? You can read faster.
passed door matters. Serial number 11. 11,
Memo, my lord. The original memo, my original color photograph is in read petition.
You will file it in the registry.
Yes.
Okay?
Okay.
Just say paucity of time.
4, serial number 16.
The appellants, my lord. I was to submit on with respect to the applications I had filed.
What are your instructions?
My lord, I'll not press my applications,
All the applications?
all 4 applications, if date may be fixed for final hearing, my lord.
Read the other side.
He is not present in court.
Just say this, learn counsel for the. Appellant says that she has instructions to withdraw. This is item 15.
16, my lord.
16.
Item 16, IA 1, 2, 3, 4 of 24.
My lord,
All the applications are dismissed and withdrawn. Now, what about this furnishing process fee, acknowledgement, correct address, R5, R7 to 9, 11?
my lord, I'll do the needful. My lord, and, but if my understanding, my lord, is that all the contesting,
Oh, no, fella, these applications for implement of 12 to 15.
my lord,
Not 5, 7 to 9. They were parties.
they were parties, my lord, and all the contesting respondents have already filed wakalat and they're on record.
Okay.
A date may be fixed for file.
Let's be clear on this. This one R5, R7 to 9, 11, sir.
No, sir, not sir.
My lord, if I'm not mistaken, caveators are on record.
Caveator is for R1 and 2, sir. One
If
and
my lord
one,
would-
respondent number 10.
If my lord would see the order dated 17/3/2023,
Then 10 appears there as the caveators.
my lord,
Will be issued for service on R5, R7 to 9, R11. Correct. Returnable law.
one submission, my lord. I think some of them were placed ex parte. May I just give the names of the respondents who were placed ex parte in the suit?
It says the address need to be given.
Some of them were ex parte in the original suit, my lord. I'll just. They're all ex parte in the suit is what I'm given to understand.
No, you tell us, we will say we
My
will
lord.
dispense with at your risk.
My lord. My lord, respondent number 7 was ex parte, 8 was ex parte. Respondent 9 was ex parte, my lord.
And you have to tell us you want to serve them or not.
My lord, those who were ex parte, notice may be dispensed with.
Very good. Counsel for the, just cut that. And the counsel for the appellant states that the notice to respondent number.
R4. R,
Four is already.
my lord, R4. R7, R8, R9,
Seven, R8, R9.
9, R12 were ex.
R12 is the.
No,
there is no R12.
No, sorry, R11, man.
11.
R11, Jyoti was,
That R7, R8, R9, R11. No
But-
need to
my lord.
states that the notice to the said respondents be dispensed with. Be dispensed with as they were ex parte before the court below at the risk of the appellant.
My lord.
Appellants noting the said statement, submission, the notice to the aforesaid respondents are dispensed with. Notices to the said respondents are dispensed. Let's the appeal on. Everything are there, paper books, everything?
Yes, everything is on
You'll
record.
see, that's all.
May I seek one final indulgence, my lord? May I be, in the event of any delay in disposal, may liberty be reserved for me to maintain?
Say nothing,
My only apprehension is about equities being created, my
say
lord.
nothing, ma'am. We have said on interim, we have seen it, we have seen your past order, you went to Supreme Court, matter retained finality. If in law you have any remedy, you will seek those remedies. Okay.
My lord.
23, so number 23.
But this is a case, my lord, where I have not filed an application under 21 rule 97 as an objector, my lord. Trial court has refused to consider it, not considering my conduct that I had filed an impleading application and that had been rejected earlier. Against that, I had come before this court, my lord, and the learned single judge had said, my lord, that the decree will not be binding on me, my lord. Therefore, my lord, now there is a delivery warrant already issued. Lord, because I am in possession of the property, my lord. I am in possession of the property, my lord. There is, during the, my lord, currency of my tenancy, another tenancy is created.
The order 21 is nice.
Because 102.
Yes, my lord.
102, man. Or 21.
Yes, my lord.
So it's almost a similar inquiry.
No, it is a decree, my lord. Yes. And
But possession was not delivered. It's a false statement. Let my learned friend show in the agreement.
I can.
Where is the possession? Initially, no.
I will
His
point
father,
out.
1 second.
In terms of his sale deed.
No,
No.
there is no sale deed. It's an agreement of sale. He is now bringing
But may I-
in 2000, 1 minute. 2018 agreement of sale. He is now relying upon saying that I had an agreement of sale with the respondent, contesting respondent. They are the petition before the trial court. What were he doing? He could have prosecuted separately for seeking a specific performance of the agreement.
But you had the sale deed.
No, I am the owner of the property. I had given lease to his father. My son has been set up by the father.
What is the decree now?
Decree for possession.
Ejectment, my lord. I'll
Ejectment and
point
also
out.
arrears of rent
My lord, right from 2008,
Ejectment against whom?
against the
Father.
father.
Or against the father?
Yeah, father of the.
Son.
Yes, son has been set up.
not set up, my lord. Right from 2008, my lord, I am a tenant there, my lord. I have been paying rents. I have the document, my lord. Every month, we have been making payments, my lord, by way of, my lord, bank transfers, my lord. Now,
Initially,
what they do during the currency of my tenancy, they create a document, my lord, between the daughters of the owner, that is the father of the plaintiffs, my lord, is the person, he's the owner, my lord. He has executed an agreement also, my lord, in the meanwhile, to sell the property to me. I am running a news channel in this property, my lord. I have invested crores of rupees in this property. Now, what they do is they create a document between my father and the daughters of, my lord, the original owner. I am in possession. I can
I'm
prove.
sorry, father, against the father, we have filed these cases and then he is in possession. Now eviction is ordered against him and to pay the arrears of rent, son, my lord, the same
In the stage,
for delivery warrant.
delivery warrant.
Yes, my lord. And he has filed an application initially when the suit was
The areas.
about 2000. There are 4 matters actually. 2 are listed. They're all apartments.
As far as I am concerned, there is no arrears, my lord. I am paying the rents even today.
Where is the father?
Father, he knows better.
Lord, kindly see, I'll just read one
Initially,
one
my lord,
paragraph
when
in the
when
judgment.
original
of the-
suit was,
The execution.
but the execution now it is posted.
No, it's,
No,
Lord,
when is the
delivery warrant has been ordered, my lord.
delivery
Next
warrant
date is
ordered?
27/3, my lord.
Case is posted to 20.
1 minute.
No, correct.
Whereas initially,
But it
when the
will-
original suit was pending, same person filed a
Lord,
pleading
yeah.
application that was rejected by the trial court, came before here. And this honorable court observed that anything you want, you can put in the execution proceedings. He claimed that he was a tenant in that application. That came to be rejected. Now we have set up agreement of sale in the execution proceedings, saying that I am the objector, I am having an agreement of sale with the owner.
Nothing during the suit.
No.
No. During the suit, my
When
lord.
2018
I filed an
agreement of sale,
application.
he kept quiet. All this, even today has not filed a suit for specific performance. Sir. End of the day, if he files a suit for specific, why he will get it?
We will post it next week. We'll just look into it.
Tuesday, my lord.
Please, madam.
Okay. So do you intend to seek that execution of the?
No, we will keep quiet. We'll keep.
Till
quiet.
11.
We say nothing.
Please, madam,
Just
don't do
re-notifying.
anything. We'll under.
Simply re-notifying. Just say that
Please.
because of paucity of time, matter could not be taken, list on. All right?
Lord, your lordship may indicate a date, my lord. 11th, my lord, if your lordship can. Yes. No, it may not.
1 minute.
Some, next week. Huh?
Huh?
12.
12.
Deeply obliged.
That's all.
Please.